Good morning, Mr. Good morning, Mr. Bodlani.
Good morning, Chair.
Good morning, Advocate Johnson.
Good morning, Chair.
Let's start here. You remember yesterday we gave you some homework that stemmed from a question put to you by Commissioner Baloyi. And that question concerned the 4 counts that General Masemula is charged with, all of which are based on the Public Finance Management Act, or the PFMA as it is usually called. Commissioner Baloyi's point was, Commissioner Baloyi suggested to you, and she wanted a response, that those charges cannot stand alone. They must be related to some other offenses that do fall under the mandate of IDAC. You remember the question. I added to that question the fact that the section actually makes reference to additional, and I said to you that surely this must mean that the offenses under paragraph C of section 7(1) capital letter A, those offenses under the specified statutes there must therefore be, because of the use of additional, be additional to something that's already referred to. And if it's only offenses under the statutes, then IDAC does not have a mandate. I even said to you, you must give meaning to the word additional. In fact, I should actually have gone further than just additional. I should have said this is additional related, so underline related as well, statutory offenses. So you would have to give meaning to additional related statutory offenses. And if what General Masemula is charged with are only the statutory offenses, in fact, in this case, statutory offenses relating to only the one statute, the PFMA, on what basis does IDAC have a mandate to charge General Masemula under the PFMA, standing all by itself? Unless you have a different, or you give the words additional related statutory offenses a different meaning to the one I'm suggesting to you. Can you please respond?
Good morning, Chair and Commissioners.
Yes, good morning. Good morning, Advocate.
I've done the homework. I don't know if I'm going to pass, so we're going to give it the best shot that I could. I did go back, and it is correct, Commissioner Baloyi, that he faces charges relating to the PFMA. And so we've got to go back into section 7, especially 7(1)A, and say, in the absence of. Now, we have several accused that are charged. And you will find that not all of the accused are charged for all of the same offenses. You may find that some face 3 or 4 and some face just 1, etc. But they all arise out of the serious, complex corruption and commercial crime matter, which is the Medicare matter. It is in that vein that we go back, Chair, and when we look at section 7(1)A, the sub-A, our case, the Medicare matter, relates to serious, high-profile, or complex corruption, commercial or financial crime cases. That is the umbrella of the cases. The involvement of Commissioner Masemula in relation to the serious, high-profile or complex corruption, commercial or financial crimes are as related to the PFMA. When these offenses were allegedly taking place, the serious complex commercial, General Matlow, from the risk audit of the police, brought it to the attention of the then commissioner to say that there is these offenses taking place. There's unlawfulness happening in this contract. And commissioner, as the accounting officer, you need to stop the contract and therefore it would therefore stop the payment. It took him a long time to do so. And what then happened is, in not acting in terms of his duties as the accounting officer, to act promptly, to act diligently, monies were in fact then paid out because of these unlawful corrupt activities in the approximate value of 50 million rands. And then the contract was stopped. He said it is all flowing out of the main transaction. It was brought to his attention, and the bringing it to his attention is because he is the accounting officer. And had he acted, then the perpetuation of this unlawful corruption, commercial and financial crimes would not have taken place. It is so, Chair, we never said that he was party to the corruption, but he is being charged then for the PFMA arising out of those matters that he had become aware of, and that we say he then did not stop. And that is as...
That's a valiant attempt, but I do not think it takes you to a pass mark. Let me make a very cruel example and say, let us say all of the people that General Masemula is charged with were dead, all of them. And therefore there was no question of them being charged with all the offenses, with any of the offenses you are seeking to rely on, and to suggest that General Masemula's charges are additional to. So General Masemula then has to be charged under the PFMA all by himself. So what would the PFMA charges be additional to? What would the PFMA charges be additional to? Nothing. You get my point.
Yes.
So it's on that basis that I say your attempt to just force the PFMA charges being additional simply does not work. Do you agree?
Chair,
it doesn't. It doesn't. Because all that General Masemula is charged with are the PFMA offenses. So when you look at him, those offenses, insofar as General Masemula is concerned, are not additional to anything, are not related to anything. It's just those PFMA offenses only. And you cannot force the additional by merely relating to charges faced by other people, charges that have nothing to do with him whatsoever. And the cruel example I give actually makes the point abundantly clear. Do you agree?
I agree, it makes the point clear.
Yes.
If you'd allow me to, and then I stop.
Yes, yes.
In the manner in which it transpires, the PFMA is in relation to, and that is as far as I take it, it is in relation to the serious complex corruption, commercial and financial crimes. If those had not taken place, there is no need for the charge to be preferred, PFMA or otherwise, against Commissioner Masemula. But that is as far as I can take that argument. And I just wanted the opportunity to explain where I took the in relation.
But for as
I
long
hear
as,
you.
oh, sorry, please finish.
No, I said
Yes.
that is as far as I'm able to take it because it is in relation to.
Yes.
Had those not
You
happened,
see,
there wouldn't have been these charges.
Yeah, you see, for as long as you agree with me and you are not able to argue against my cruel example, that point simply does not work. It doesn't. Because if he was all by himself, you couldn't, it would be nonsensical to talk about additional, because it would be additional to what? Additional to what? Because that additional is a conscious choice of word by the legislature or the legislator. It's a conscious choice of word. Otherwise, they would just have said relating to these statutory, or rather, offenses arising from these statutes, and then the statutes would be itemized. The use of additional is because there must first be other offenses. Otherwise, additional simply does not make sense. You must accept that.
I leave it there, Chair.
Do you agree that otherwise
I have to agree with your reasoning.
Sorry.
I have to agree with your reasoning.
Thank you.
I made the point I thought I need to make.
Yes,
It is based on my understanding. And I have.
Yeah, I suggest to you, or as other people would say, I put it to you that your reasoning in this regard
will not hold water.
It simply does not. Thank you.
Advocacy law, there's a further issue on this. If you go to file 9 on page 3520, this is General Matlow's own affidavit.
Sorry, Advocate Johnson, you should not leave your seat when your testimony is concluded, being under the belief that the commissioners are suggesting that General Masemula has no case to answer insofar as the PFMA is concerned. We are not suggesting that at all. What we are focusing on is IDAC's mandate. IDAC, insofar as the PFMA is concerned, on our reading, IDAC's mandate is only if there are other charges and then the PFMA charges are additional to that. That's all that we are saying at this stage. It's about IDAC's mandate.
I hear
You see what I mean?
I understand.
So whether or not PMA offenses have in fact been committed is something else altogether, but it's not something that must be pursued by IDAC. That's all we are suggesting to you.
Thank you, Chair.
Thank you.
Yes, thank you, Chair. Good morning, Advocate Johnson.
Morning, Commissioner.
I'm going to deal with process leading to the charges by IDAC. So the Section 27 affidavit or
Sorry,
additional...
Chair, I think sorry, Commissioner Khumalo, I don't know if the Chair found his file. It was file, you got file 9. Sorry.
Yesterday already I did. Thank you very much, Advocate Johnson.
In your response to Chair, you referred to General Matlow's affidavit. So if you look at General Matlow's affidavit starting on 3519, what she says in 3520 in relation to General Masemola is that, so first of all, she's the head of risk and integrity, so head of risk and compliance at SAPS. And she would have investigated these issues, as I'm sure her job description requires her to. And then she says in paragraph 8 on 3520, she then advised General Masemola to consider terminating the contract with Medicare to save SAPS from irreparable harm and to diminish the financial prejudice suffered by SAPS. Then she says General Masemola terminated. So General Masemola accepted the advice. Do you see that?
Yes.
Now, if you read section 86 of PFMA with section 38, what it requires is willful and grossly negligent conduct on the part of General Masemola. As I understand those two sections, they would kick in if, notwithstanding the advice by the head of risk and compliance, he does absolutely nothing. Because then that would be willful and grossly negligent. But if your head of risk says, I've investigated this, here is an audit report that shows that at the time when you did not know, some members of SAPS in supply chain were colluding with Mr. Matlala's company. And as a result, this contract was concluded. They were also colluding in relation to the issue of, I think it's in charge 3, of the orders, of the purchase orders, which is not something that as a commissioner you would generally know because it happens at supply chain level. If now head of risk investigates, gives you an audit report and says, the purchase order process and even the granting of the contract from the beginning were tainted by criminality. You as accounting officer, you come in at that level and you say, now that I have all this information, what do I do with it? And if upon receiving that advice, you terminate the contract, where is the willful, intentional conduct and the grossly negligent? Because the way these charges are formulated, IDAC is basically saying from the date the tender was awarded, because they say from May 2024 until May 2025. So they say from the date the tender was awarded, already there was willfulness and grossly negligent conduct on the part of General Masemola. But that cannot be if you look at the issue of the purchase orders, for example, in count 2. Those only started coming in after the tender was awarded. And payments only happened after services were rendered. So it cannot be that from the 8th of May already, because there was no tender on the 8th of May. The service provider was appointed in June, and after they were appointed, we've had evidence that there were then meetings about how the contract is going to be implemented. And the contract was then implemented much later, from September onwards, if I remember Brigadier Macheng's evidence correctly. So it's not clear to me how in May, June, July, August, PFMA breaches could have occurred on the part of General Masemola. So do you see where I'm going? That you can only sustain the PFMA charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if, after he has received advice from the head of risk, he ignores that advice and allows SAPS to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
Yes.
General Matlow, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand it.
But do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlow's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion by, if General Matlow is the complainant, there's no suggestion by General Matlow that General Masemola did nothing with my advice or he took inordinately long before acting on that advice. And as a result of his failure to act on the advice, there was the loss. How I read this affidavit, it says the 50 million is what was paid throughout, not after the advice was given. But the charge sheet creates the impression that the loss happened after the advice was given.
If I could just indicate, Commissioner, that I asked if there was only the 27 at the time when they had this matter. I'm given to understand that General Matlow submitted a preliminary report together with the Section 27 affidavit. I'm not sure if it is before the Commission, but that must be something that that would then have to be asked, as it might just give a different context, but I'm not seeking to take the point further in terms of the conversation, Commissioner Khumalo, between you and I.
But looking at only paragraph 8, do you accept that the General says, I gave advice to the National Commissioner, the National Commissioner acted on the advice? The affidavit does not say the National Commissioner failed to act or did nothing with the advice given to him.
I understand that.
Yeah.
Still on this issue, my concern in the debate about whether or not this falls within the IDAC mandate is that on the charge sheet itself, there is no allegation of corruption. You don't make that allegation in the charge sheet. The charge sheet and the charges are purely statutory contravention, PFMA, and working off the charge sheet as it is now, the impression that it creates, or that in my mind has formulated, is that there was no good faith intention to prefer a charge because it is justified, it is supported by the facts. This was just a scheme to get him arrested or present to court, to have him appear in court, and the purpose is achieved just by that fact alone. So you don't even get to the validity of the charges. That's why we don't discuss with you whether there's merit in the charges themselves. That's for the court to determine eventually if it does. But that which is obviously, at least in my view, which is obvious from the charge sheet and must have been obvious to the lawyers in your office and to the prosecutor who approves those charges, it must have been obvious just on the charges that we are not making an allegation of corruption against him. How do we justify him being here? That must have been obvious. And accepting, because it's difficult not to accept that it was that obvious to the lawyers who dealt with this. accepting that it would have been obvious to them that this charge sheet is wholly inadequate for purposes of our mandate, there has to be another reason why, anyway, you approved the charge. If you did do a prosecution memo, you were prepared to do the prosecution memo and say to the prosecutor, I think you said it's the DPP, and for the DPP to approve this charge as it stands without saying to you, hang on, go back, include corruption in there so that it falls within our mandate. To me, it gives the impression that the whole purpose of this charge sheet was to just have him appear in court. Just have him, let's create a paper that presents him to court and he becomes an accused with a consequence that we now publicly know happened, which is he was removed from his position, whether it's a leave or suspension, whatever, but he's not in office. And I say that, and forgive me if I'm repeating myself, I say that because it's inconceivable to me that a whole lot of lawyers who looked at this charge sheet, none of them said, hang on, we can't do this. This is not good enough for purposes of our mandate. If we want to charge him as involved in corruption, even your interpretation that you give to the chair this morning, if that interpretation had been discussed, it would find reflection in the charge sheet. However, inelegantly expressed, if the idea was that, well, you know, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here with a lawyer's eye. And that it doesn't find expression suggests to me is because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct. And for that, you couldn't go that far, but it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister, and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloyi, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality, and as I explained this morning, it relates to. I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did. That link is not there. That cannot be taken away. But it should therefore not be seen as it was used as an instrument. They still firmly believe in those PFMA charges as they put them. And in my discussions yesterday, I did highlight that the Commission does find we have, where is the link between the two? Hence my explanation this morning. I took your point, but I have to clarify, there was never an ill intent. It might have been clumsily put in the way it is.
Or incompetently
drafted. Put, but that does not make for ill intent at all. Thank you, Commissioner.
Thank you. Thanks.
Seeing that we are dealing with these PFMA charges, perhaps let me take you to a different but related issue. Ms. Sello, please please.
Yes, Chair.
Let me do so, Advocate Johnson. I'm sure you know what sections 155 and 156 of the Criminal Procedure Act provide with regard to joining accused persons in the same set of criminal proceedings. Perhaps for the record and those viewing these, for their benefit, those viewing these proceedings, let me read both sections. 155.
Chair,
yes.
Apologies, we are trying to project, so perhaps when you read, it will be projected as well. Thank you.
All right. Section
157.
155 and 156.
155
And 156, so Criminal Procedure Act.
It's coming up. Thank you.
155 is headed, persons implicated in same offense may be tried together. So I would say, please underline even that heading itself. Of course, our law and interpretation says a heading may be a guide, but is by no means determinative. But I will say, let's underline it. Then the subsection 1 reads, any number of participants, and I emphasize what follows, in the same offense, so you underline same offense, may be tried together, and any number of accessories after, again underline, the same fact may be tried together, or any number of participants, again underline, in the same offense, and any number of accessories after that fact may be tried together, and each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against, I will say, them. Surely, in charging General Masemula together with people charged with fraud and corruption, you did not rely on section 155, subsection 1. I must be correct in that view.
That must be correct.
That's correct. Okay, let's go to, I don't think subsection 2 is relevant, so let's skip to section 156, which is headed, persons committing separate offenses at same time and place may be tried together. That too is quite crucial because I'm interested in it. If we look at what Commissioner Masemula is charged with, one immediately wonders if it can be said that he committed offenses at the same time and place with the people that he has been lumped with. But again, I will make the point I made earlier that a heading is merely of assistance and not necessarily determinative of the interpretation to be given to a statutory provision. Okay, let's go to the provision itself. Any number of persons charged in respect of separate offenses committed at the same place and at the same time. Underline that. Now it's in the substantive part of the provision, so no longer just the heading. And, or at about the same time. So that too, at about the same time, may be charged and tried together in respect of such offenses. And then here's another crucial part. If the prosecutor informs the court that evidence admissible at the trial of one such person will, in his opinion, also be admissible as evidence at the trial of any other such person or such persons. Do you think this subsection applies? Or rather, this section, it has no subsection. Section 156, do you think it applies? In what way, as General Masemola, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption. Surely that cannot be suggested, I do not think. Same place, same time, about the same place, same time as the commission of the fraud and corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemola was wrongly lumped with these other people. You must accept. You accept that?
I see that.
You certainly must. Now, even when you look at jurisprudential precedent, I will refer you to, I know you're a good prosecutor. I watched you arguing, which appeal was it? The Pistorius appeal. You are actually a good advocate, I think, on my assessment. I will refer you to jurisprudential precedent with regard to the court's exercise of discretion under section 1, under one of the sections I've just referred to. It should, I think, be relevant more to 156. Let me just see if the case was dealing with 156. Anyway, let me not waste time. Let me just read you what Trolip J.A. held. He says, in exercising its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused. That is, the applicant accused would be the one saying, please, please, let my case be separated from the cases of these other accused. So the applicant accused, resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not, in the interest of justice, a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that you've already accepted that in any event, General Masemola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemola is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to what I suggested to you now?
And I wanted to say that because of, if you read 157,
yes.
that becomes a bit more, is more appropriate then in the circumstances and given the jurisprudence.
Yes. But you basically agree with me, you've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that the General Masemula has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily, you know these principles, you apply these sections all the time. Why was this done? Why was Commissioner Masemula lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there, people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemula. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemula was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery, right?
The prosecutors.
My question is, before that decision or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are.
Based on the contentions that I've given, which was given at the time, yes, ma'am.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened, we just lumped these people together instantaneously, it sort of just happened. But anyway, I say, things like these cannot just happen. So if it's wrong in law, it would have been wrong, even if it was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you said there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be charged jointly? The prosecution
you
team...
can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate 155 because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masemola.
So you were part of that discussion, you say?
With the prosecutors. Yes, when they did the briefing. Yes, there was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal basis that we found, Chair, it was the argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud, admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as he is concerned? Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemula. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemula, you do not get off the starting blocks under 156. Do you agree?
I agree.
So he
I was giving you the discussions that we had.
Which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.
Thank you, Chair and Commissioners. Let's stay with the Major General Matlo's referral affidavit. And that's file 9, page 3519. And based on your, I think, our engagement yesterday with the commissioners on matters relating to General Masemula's arrest, this is our starting point, correct? General Matlo's affidavit is what eventually triggered the arrest, the eventual arrest and prosecution of General Masemula.
On a point of correction, I did indicate earlier that she submitted the section 27
Yes.
together with a preliminary report.
Which preliminary report has not been provided to us. And I want to see how you reach that conclusion when on the wording, the very wording of the affidavit, there is no suggestion that anything is attached thereto.
I checked with the team, this 27. Did it have anything else? Because that is the question. In the absence of anything else, council, which was the conversations we were having yesterday,
Yes.
then a lot of things could not have happened. And I was informed that there was a preliminary report that was attached.
It doesn't particularly help the commission because only you and whoever it is you spoke to know of an existence of some preliminary report. The document that triggers this entire process does not even suggest it's submitting any further documentation, preliminary or otherwise. If you go to paragraph 5 of that affidavit, it speaks of a comprehensive internal report is currently being compiled. It doesn't say in the interim here is a preliminary report. So on a logical interpretation of paragraph 5 is that an internal audit process was underway. The fact that she describes it, the outcome thereof as a comprehensive report does not detract from the fact that it is underway. Do you agree with me?
I understand.
So I look at the rest of the affidavit, and there is nothing that suggests that even she, as component head risk and integrity management, had formed a view on the matter, however preliminary it is. Do you agree with me? At least based on the document itself. Do you agree with me?
I agree with you.
Yeah. Now, if we look at her paragraph 3, she says she wants you to investigate.
Sorry, paragraph 3.
Paragraph 3, yes, of General Matlo's affidavit. She wants you to investigate, you, IDAC, that's who I mean, the alleged unlawful awarding of a tender to Medicare 24, Tshwane district. You see that?
Yes.
Now, the charge sheet that came out of this entire investigation process invokes Section 38 of the PFMA, solely Section 38. And you know that if we take a step back, Section 217 of the Constitution prescribes that all organs of state should establish a system and make appointments regarding bid adjudication, bid evaluation, and that entire formal structure to deal with the issues of public procurement. So the awarding would have been done by, the recommendation would have been done by that procurement system. It then lands somewhere where the decision maker has to determine whether they accept the recommendation and they reject the recommendation. Is that your understanding of how public procurement works?
Yes.
And in deciding to reject, administrative law tells us that that decision maker must set out the reasons which must be reasonable and rational, because the responsibility and duty to manage matters of procurement lies elsewhere in the organization. Do you agree with that? Are you with me thus far?
I'm with you.
Now, with that understanding, if I go to the charge sheet and I look at charge 3, how do we rationally explain away charge 3, which is a charge of gross negligence for failure to comply, in that General Masemola, him, I take it as the accounting officer of SAPS, failed to ensure that Medicare 24 Tshwane district was properly screened and tax compliant? Whose duty is that?
That must be the bid evaluation.
So why, and now I'm just trying to get some, why is he being charged for failings by the bid evaluation committee, if we have since discovered that in the process of evaluation, it turned out that this particular entity was not tax compliant and neither was it properly screened? Unless we are suggesting the bid evaluation committee and the bid adjudication committee, after they have discharged their duties, the whole tender and process and documentation must go before General Masemola, where he must satisfy himself that this entity was tax compliant. Is that what we're suggesting? Amongst others.
Doesn't make sense.
I didn't think it would. Staying.
Please indicate to me when it would be appropriate to give Advocate Johnson the citation of the case I quoted from. I forgot to do that.
This would be good.
Should,
I'm happy to.
Thank you. I just gave you the name of the judge.
The matter from
yes,
Trollope J.
the matter, yes. The matter is S versus Ntuli and others. And others. 1978, Volume 2, South African Law Reports, page 69, Appellate Division. Thank you.
Thank you, Chair.
Can I just add, without making a debate about it, a difficulty about this count that Ms. Silo has referred to, and which is part of what leads to my conclusion that I put to you earlier, is even this count, what that provision deals with is that the accounting officer must make sure that the institution complies with its tax obligations and everything that is listed there. So it's not even about that an accounting officer must make sure that people who are service providers have complied with their tax obligations. There's quite a few obligations that are listed there, but all of it is about you would have been entitled. Whoever charges him has jurisdiction, would be entitled to charge him for not ensuring that the SAPS complies with its tax obligations. You understand the difference?
yes.
Yeah. So it's charges like that, a count like that, that reference to Section 38 as one of the charges against him that feeds the suspicion that I have about the motive of putting these charges, and me saying, but lawyers could never have missed that Section 38 1E has nothing to do with his involvement with the tax compliance of Mr. Madlanga's company. It has to do with SAPS's own tax compliance. You understand what I'm saying?
Correct, because there's supposed to have been other functionaries
Yes.
who would have gone through that process of the bid and the evaluation relating to Mr.
I think
Madlanga.
that I'm making a different point, that 38 1E is not about service providers' tax compliance.
Yes.
It's about SAPS's own
Compliance.
with its tax obligations.
Yes.
And so the charge, and I say it, I mention it only to say it's part of what makes, feeds suspicion about what was the purpose of these charges, which clearly seem to be poorly conceived against the National Commissioner, at least by IDAC. Thank you. Mr. Lt, thank you.
Thank you, Commissioner. And Advocate Johnson, that precisely makes the point, because Section 38 1E, as Commissioner Baloyi correctly points out, is in relation to SAPS's tax compliance. Yet the reading of that charge suggests that Tshwane, is it Medi 24, ought to have complied with that particular section, and that General Masemola failed to ensure that Tshwane complies with that section. You see the challenge?
Yes.
And the interesting thing is the entire charge sheet is based on Section 38, and I'm just going to quickly project Section 38, because I think this is what leads to the challenges, for instance, in count 3. Section 38 of the PFMA prescribes that the accounting officer for a department, trading entity, or constitutional institution, sub-A, must ensure that the department, trading entity, or constitutional institution has and maintains, and I will go to Roman 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective. On a reading of that, you would agree with me that that is the responsibility that General Masemola bears. He must ensure SAPS maintains an appropriate procurement and provisioning system that is consistent and compliant with Section 217 of the Constitution. Now, it is that system that receives, interrogates, bids. My logic, which may very well be faulty, would be his failing to the extent that it falls within 38. The charge ought to have been, my view, that he failed to comply with 38 1A Roman 3. He did not ensure SAPS has got such a system. Would you agree with that?
I agree with that.
Now, if we go back to charge 2, and charge 2 I will read with General Mato's referral affidavit at paragraph 3, just to remind you, at 3519, General Mato had indicated that she was initiating a criminal investigation into the unlawful awarding of a tender to Medicare. And if one has regard to 6, we learn that 7, we learned that Medicare 24 was awarded that tender, and resulting in a contract being concluded. And at 8, we learned that General Masemola terminated that contract. Firstly, if then we follow the logic of procurement, of a bid process, it culminates in a contract, and as General Matoi points out, that contract brings into being contractual rights and contractual responsibilities and liabilities. So I suggest that once a contract has been concluded, which on the face of it brings about the rights and liabilities, that contract must be set aside, lawfully set aside. Do you agree with me?
Yes.
And in fact, it would appear that becoming persuaded, he actually chose to cancel the contract. And I don't know if you are aware that Mr. Nhlanhla attempted to go to court, or there was discussion between him and other members of SAPS to challenge what he termed the unlawful termination of the contract. Now, I go back to the affidavit, armed with the knowledge that we have in the affidavit, knowing what he did, appreciating the legal parameters of what he could do and not do. How do we even get to investigation stage? At which point do you say, as the accounting officer yourself, if you're accounting officer of IDAC, the head of IDAC, at which point do you say this is a non-starter insofar as Masemola is concerned? Remember, I rejected the notion that there was a preliminary report, and I rejected on the basis that this very affidavit doesn't even suggest one was tendered. How? I still have a struggle with how this even saw the day of light insofar as Masemola is concerned. And I was hoping that perhaps you might shed light and draw attention to some document that perhaps we may have overlooked.
I can't take you any further other than if they had presented the preliminary report, it might have given us a different perspective. Not having it means I have nothing to give you.
Yes. Now, it's a pity the system is a bit slow. You recall yesterday I suggested to you that that internal audit report that General Matlow references at her paragraph 5, as I understand things, it's what gave General Masemola the basis to terminate. You don't have to agree with me. It's what I have learned in the course of investigations. So when it does come before us, its date would precede the date of termination by General Masemola. So he acted upon the advice of internal audit, seemingly. Would you have difficulty with that proposition?
I have to take your word for it because I have not seen it and I don't know it.
Yes.
And I don't believe you'll put a proposition that later on you can't back up. So
No.
I accept it, Council.
Thank you for the confidence.
The same point you made with paragraph D of section 38, with paragraph
Yes.
E, applies with regard to count 2 and paragraph D.
Indeed.
Because if you look at F says he must settle all contractual obligations and pay all monies owing. So for as long as the contract was alive, he had an obligation to pay Medicare 24. D deals with something completely different. So breach of D is not consistent with count 2. Because count 2 is about it's about maintenance and management of assets. So make sure that assets don't get lost. Make sure that if you have liabilities, they are managed. But the charge says he shouldn't have paid invoices. He shouldn't have accepted orders. Now, if he did as the charge suggests, he would have breached F of section 38(1).
Indeed, Commissioner, and to assist you, Advocate Johnson is projected the subsections D and F. We've spoken about E, D, F, and D is relevant to count 2. It is on the screen, and that is what Commissioner Khumalo is referring to.
So under F, Advocate Johnson, for as long as the contract was alive, SAPS had an obligation to accept purchase orders and to pay invoices. But the charge suggests that General Masemola should have acted contrary to 38(1)F and not paid the invoices and not have accepted the purchase orders.
I see.
Do you see the problem there?
Thank you, Commissioner. And then staying with the issue of the internal audit report, which you accept, my proposal that it is on the basis of that internal audit finding that General Masemola terminated the contract. And the proposition to you was if he terminated on the 15th of May, that audit report was availed to him prior to the 15th of May. You do accept, you said you accept, at least for the moment, because you haven't seen it, I accept that. And I thank you for having the confidence in me to accept my say-so. The point I seek to make now, though, is the facts of that report and the findings only came to the attention of IDAC on the 26th of June, 2026. Now, as I was complaining that the system is rather slow this morning, that was by way of a further affidavit by General Mkhwanazi, dated the 26th of June, 2026, which currently, I guess, is in printing and copying. It's a big document in that I think it's a 284-page affidavit in which the introductory paragraphs are the same as any affidavit. From paragraphs 2 to the penultimate paragraph, it's the entire reproduction of the report itself, together with its findings and recommendations and everything. And then it's got whatever paragraph it will be as a concluding paragraph. And she signs it on the 26th of June, 2026. So officially, for purposes of investigation, that is the first time IDAC even becomes aware of the basis on which General Masemola eventually had to terminate on the 15th of May, 2025. You would accept that. Logic would tell me. Unless, once again, you or somebody within IDAC were able to explain that they obtained that audit report prior to the complainant, General Mkhwanazi, submitting it in a form of an affidavit on the 26th of June, 2026. Now, to the extent that your investigators told you there was a preliminary report, which of course I take issue with, did they indicate when they received that final audit report prior to the 26th of June, 26, if they ever did?
No, I just know that there was a preliminary report with the Section 27.
Then
I don't have the details, Chair, unfortunately.
We will await that affidavit and see. Now, this is, again, I'm still staying with General Mkhwanazi's affidavit, and it's because these are now significant and important institutions in the country. This is IDAC, SAPS. When this affidavit is received in the terms that it is, it does not at least implicate General Masemola on the face of it, does it? The affidavit at 3519.
Oh, you're talking about the Section 27, sorry.
Yes, the Section 27
Yes.
from General Mkhwanazi.
No.
It doesn't implicate General Masemola.
Sorry.
The only reference I see to General Masemola is at paragraph 8,
Yes.
wherein she states that she advised him to terminate, to consider terminating, which he eventually did on the 15th of May.
Correct, but she does go on to say, in her way, that having advised the National Commissioner to terminate the contract with Medicare to save the SAPS from irreparable harm and to diminish the financial prejudice being suffered by the SAPS, General Masemola ultimately terminated the contract with Medicare on or about the 15th of May. By that time, SAPS had suffered prejudice of approximately 50 million.
And that prejudice of 50 million being what SAPS was obligated to pay in terms of the contract. That's what you call prejudice.
At that time, when she told him about the termination, she indicated this contract is unlawful and should be stopped So I don't know how the payments then become legitimated.
So,
I understand that the system in terms of the system, there is a contract, till it is stopped, payments will continue. I understand this to read,
Advocate Johnson, apologies.
sorry,
You and I know she has no power to invalidate a contract which on the face of it is valid. So when she says stop that contract, in what capacity? She's not a court.
she's not a court, no.
Yes.
But she is the risk, she's the head of risk and integrity, and she is saying to him that this contract has been unlawfully awarded, and we need to stop the contract. She says because of the time that has passed, the payments went out.
Sorry, this affidavit doesn't say when she told him to stop. So, on this affidavit, at least we who are reading it now, and maybe you had other information that is not in the affidavit. On this affidavit, we don't know whether she told him in January, whether she told him on the 14th of May, and what the expenditure was by the time she told him when it dawned on her that this contract should be terminated. So it's not, what you're telling us now is not in the affidavit, so maybe tell us, where did you get it from that she told him to terminate, he did not, and in the intervening period after that, and the 15th of May, 50 million rand was spent, which would not have been spent had he acted when she told him. There's facts that are not contained in this affidavit, and they hold only if you got them in another way.
I understand. It's how I read the affidavit, that there is, in paragraph 2, there's an unlawful awarding of a tender to Medicare for a period of 3 years to the value of 360 million. She sets out that she suspects that
Please
the processes are flouted.
allow me to stop you. You have accepted in your discussion with Ms. Sillo that the only mention of General Masemola is paragraph 8. That's the first time she says anything about him. That doesn't mean that she has not investigated and this is what she has found. She has done that. That's why she gives you the background story in this affidavit. And then at paragraph 38, she says something that now directs to General Masemola. And in fact, on a reading of this paragraph, the way she says it, she may not have intended to, but the way she says it is, I advised him to terminate and he did terminate. That's what paragraph 8 tells you. You say, well, she told him earlier, he took his own time to terminate when she had told him earlier. And all I'm putting to you is that which you are saying doesn't arise from this affidavit. On a sensible reading of this affidavit, and paragraph 8 in particular, or any paragraph in the affidavit, those facts that you are now speaking to are not here. Where did you get them from?
Commissioner Baloyi, I read paragraph 8 as her having advised him to terminate the contract. General Masemola ultimately terminated the contract. That he does. I read it from that ultimately. There wasn't an immediate action. It was ultimately terminated and then prejudice was suffered. I don't take it from anywhere else, but just that reading.
But you see, to criticize him for not terminating immediately, you must know when was he informed.
I understand.
Logic dictates that.
It doesn't come out of here.
Yes, and that's a simple point I'm making, that on this paragraph in the whole affidavit, we don't know when she told him, right? So if we don't know when she told him, we are not in a position, and that you must accept, we are not in a position to say he delayed actioning her advice because she doesn't tell us when she informed him. We are not in a position to say because of his delay after she advised him, SAPS incurred 50 million rand expenditure, which it would not have incurred. it's not there aren't facts in this affidavit that make us able to conclude that therefore he delayed and he's liable, he failed to secure the monies or the assets of SAPS. You accept that?
I accept that.
All right, thank you.
Thank you, Commissioner. And I take it that it is General Matlo's affidavit that triggered the IDAC investigative powers and eventual prosecution of however many accused there are. Am I correct?
Correct.
You recall we started this conversation having considered what you stated, what you discussed with members of ad hoc. And there I referenced page 586 where Mr. Nhlanhla told you that there was an allegation that IDAC is actively participating in a well-coordinated attack against General Mkhwanazi, General Masumula, and General Khumalo. Are you aware of it? You said you've heard of that allegation, but there's no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no, sorry, I don't have my file for the,
No, ask
if you
me,
just
I'll-
repeat the words.
the engagement at ad
Ad
hoc?
hoc, yes.
It is it's file 3, page 586.
Sorry, file 3. Sorry, Chair.
It's quite in order, page 586.
586.
Midway the page. This is after, I guess it will be faster to find your own name, after you say that is correct. Then Mr. Nhlanhla puts the question, there is an allegation. And then that's immediately followed by your response, and then you reference other criminal matters within the IDAC space. And you conclude, while we're at it, with the words, there is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDAC prior to the referral by Mr. Adams. That's the... That's the part I'm reading. And I can very well perhaps appreciate the position you were in at the time you responded. Mine is slightly different. Do you still maintain the position after our 1.5 days of engaging with specifically decisions by IDAC targeting, no, wrong word, aimed at least 2 of these generals and the PKTT? Can you still say the narrative is baseless?
Chair, the response I have is, at no stage did any of these cases start on the basis of wanting to target any individual, even those that I mentioned. We dealt with the investigations. In the course of these 2 days of engagements, and in the manner in which we have engaged, we would have to accept that we could have done things differently and or could have done things better. But that does not in itself make it a witch hunt or a target. They were not targeted at all. I accept that process is criticized. The manner in which things were done were criticized. I accept that criticism, Chair. And what I'm saying is that shortcoming does not make a targeting. It does not make it a witch hunt. It does not of itself say, we did it this way just to get to them. In the manner that these matters were presented, it is clear, and from the lengthy debates that poor chair has had to have with me in getting us to understand our logic versus that logic, it is clear that we worked on what we had, interpreted the law as we have. There is a difference of opinion, and that difference of opinion, Council, highlights that things look the way they do and should have been done differently.
We dealt with your, one of the many Section 28 summonses.
Are you leaving this
No,
page?
I'm coming back to it.
Okay, thank you.
And at 3361 file 9, and we dealt with that quite extensively yesterday. I'm at 3363. Where, following Mr. Adams's complaint, in whatever terms it was expressed, you signed off on a summons that asked for a litany of documents that had no bearing on the complaint, including a list of all provincial heads and section heads who were stationed in Division Crime Intelligence, the performance assessment of all major generals for that year, the advertisement for that position, audio recordings and interviews. Then you want documentary records that General Jacobs refused to return. We have established that all those factors bear no relevance to the complaint. And I think we settled that yesterday.
We have.
We have. Then you ask, in the same summons, for documentary files and applications for promotions and commanders and members of the political task teams through deviation. According to you, the PKTT did not feature anywhere. So once again, that is way beyond the scope of the original complaint by Mr. Adams. You recall?
I recall.
We then went to page 3531, which is annexure, you don't have to go there, annexure 397. That is the Section 28 summons signed by Advocate Manilao, which wanted the identities and certified travel documents of PKTT members who went to arrest Mr. Adams. And he does so under the cast number relating to the Mukwele appointment. You could not explain that Section 28, and I think we landed at a place where you said it ought not to have happened. Correct?
Correct.
In light of at least the three that I have named, logic dictates that it was a concerted effort to either discredit or somehow prejudice them. How can you sit there and you say the narrative is entirely wrong? And how do you suggest that it's just a difference of opinion? It's not. The facts, at least, are on the side of the narrative. What facts do you put forth to countenance that?
If you grant me an opportunity
Absolutely.
just to answer on why, because I had to ask the question, because I wasn't aware of this, Commissioner Baloy. I did ask Advocate Manilal why this Section 28 went out, and I give you the explanation as follows. Part of the bail conditions in that matter was that the accused, which at the time would have included Lieutenant General Khumalo, were not to have any contact, interfere with, and or intimidate state witnesses, one of which was Adams. It is seen on television that there is a group of persons that have gone ahead to arrest Mr. Adams. That arrest has nothing to do with us. It is the police must carry on and do their work. There were reports that it is PKTT members who went to effect the arrest. It is now at this stage not a secret that the coordinator of the PKTT is Lieutenant General Khumalo. And the purpose behind it from the prosecutor was to determine whether someone else within the PKTT approved those trips, that is fine, and that if it was in fact General Khumalo who authorized those trips, then he was sending people to deal with Adams, and it could have a potential of interfering with the bail condition. It was asked on that basis. What subsequently happened is Mr. Adams appeared in court. The charges are read, and Mr. Adams has a way of how he expresses himself in public, and the prosecutors decided, the approval notwithstanding, can we just stand back and let them continue with their work? It was
Advocate Johnson, I want to say if that's the explanation he gave you, it's a false explanation. Those individual members and anyone else in the world was under no bail condition that they could not, that's one reason, that they could not deal with any witnesses. There was nothing like that. If indeed the issue was to determine whether General Khumalo breached a bail condition, it was simply, and I'm sure Advocate Manilal knows that, you know that, it was simply a matter of asking General Khumalo, did you authorize an arrest of Mr. Adams? It's as simple as that. So if he gave you that explanation, it's false. He's not telling you the truth about why those questions, because that doesn't answer who went there, what are the names, give us the flight details. It doesn't answer the question whether there was a breach by General Khumalo of his bail condition. So no, I'm sorry, if you believe him, then something is wrong in this scheme of things. You should have, as soon as he said it, you should have seen it on his face, but that cannot be, it doesn't make sense. That you would go that way to try and determine that General Khumalo, whether or not General Khumalo has breached his bail condition. It's a false explanation.
So, Commissioner Balwe, I hear you. I'm conveying the reason that was given. But Commissioners and Chair, you would remember my answer yesterday. I did say that if, in the manner that this process was used and what was requested by asking about PKTT, then it is an abuse of the process. I did stand by that, and I did indicate that there would have been a better way for us to have engaged and to find out what had gone on. I'm not deferring from my point. I don't retract my point. I just wanted to merely give clarity on, because I had to ask. I didn't know.
My hope is you saw through that explanation. And that's what I would have hoped you would say, that this is what he says, but I have a problem with his explanation.
That is why I stand by the proposal I made yesterday. I can't deviate from that proposal.
Yes, thank you.
And the problem is in all that we have dealt with, particularly that arrest of Mr. Adams, it doesn't seem like anyone bothered to establish why he was being arrested. Had he committed, is he a suspect in a particular crime? How it comes across is because he was a complainant in some matter against inter alia General Khumalo, who happens to be the head of PKTT, a beggar subunit, that therefore Mr. Adams is somehow insulated from action by the PKTT, even where the PKTT has evidence of wrongdoing. That's the effect of it. So you brandishing that condition over General Khumalo to say, whatever wrong he commits, you dare not touch him because he's my witness, and if you do, you'll be breaching a bail condition. That's quite a bridge.
Of course, it doesn't make sense because what I did do in that engagement, I asked
Please continue.
I asked this morning, if in fact, heaven forbid, but if in fact Mr. Adams committed what one would consider a political killing, what would we have asked? Why would we have asked? Because they would still have had to do their work. So it all comes down to the same thing. If they had a job to do, they should have been allowed to do the job.
Yes. Now, this is important, again, once again, going to the narrative, because what appears, at least at first blush to me, is IDAC seemed to have this gunshot approach to everything. That gunshot approach has got serious unintended consequences.
Perhaps more appropriately, shotgun, not just any gun.
A shotgun approach. It's got serious consequences. Let's go to General Matlo's referral, which we have agreed is wholly non-compliant with Section 27, which, based on our conversation over the past 2 days, did not trigger the mandate of IDAC. But we are where subs seem to have concluded an unlawful contract with Mr. Nhlanhla. But the prosecution for that sits on a highly questionable legal basis. Do you see the consequences? Because if the investigation is unlawful, the question must arise, what effect does that have on the prosecution? Ongoing prosecution. Instead, had IDAC opted, in light of General Matala's affidavit, General Matlo, the Sotho names. Oh, I do apologize. I apologize to both General Matlo and Mr. Nhlanhla.
No, I think the second name is Nhlanhla.
Yes, I was going to say that, Commissioner Baloy. I saw
I
saw the words charity, Nhlanhla Matlo.
Thank you. Thank you.
No,
she intended to say Matlo, Commissioner Baloy. Just thank you, General Kumalo. My eye must have fallen on that. My apologies for that.
Now you've called him General Kumalo.
Okay, it's time for a break. Commissioner, I'll leave it there. The point I seek to make with you, Advocate Johnson, is that this affidavit ought to have at least triggered a conversation between yourself as head of IDAC and General Masemula, who at this juncture is not even a suspect in any wrongdoing, to alert him to the fact that there is a contract in your environment that there is reason to believe is tainted with illegality, and I expect you to take steps. The point I made that a faulty Section 27 may affect subsequent prosecution. You remember the fruit of a poison tree notion we discussed. And that's your challenge as IDAC. But if subs had run with the matter, they would never have this challenge. So because of the approach that IDAC has adopted, that running roughshod over everything, there is a serious risk, and I put it no higher than that it may have placed in jeopardy the very prosecution that is currently being pursued. Do you have a comment?
My comment, and again, you'll tell me, but it's not here, so my comment is that 27 was read, as I understood it this morning, with the preliminary report, which sets out a more factual basis that links the different people and perhaps sets out the offenses. It might be better if, so I see, sorry, Chair, I'm not being cheeky. I see from the time that my wish to finish by tea time might not happen. And so I'm tired. But so I'm thinking then that if we're going to have to take tea and we're going to now have to finish by lunch,
Let us,
that I would have to ask if we could just get them to send us this preliminary report, because I cannot agree to that contention. I'm giving you what I have, that there was a basis for it. This 27 is not even open for a debate about the discussion we want to have, but I am unable to reconcile that they had nothing. There was a preliminary report that went with the affidavit. For me to agree to a contention in the absence thereof is highly irresponsible, and one that I'm not prepared to do to future, that in all likelihood has a sound legal and factual basis. And that is where I wanted to take the point. And then I'll take my cue from the chair about what we're doing for the rest of the day.
I would support
go ahead.
I would support your request. I think it's a fair request, right? You have accepted that, at least on the documents that we have, on the reading of the affidavit itself, it doesn't suggest that such a preliminary report was provided.
Yes.
But since you've been made to believe that it was, I think it's a fair point that you consider it. You receive it, you consider it, perhaps you give the commission a copy, and then we see whether or not it addresses the concern that I have raised. And seeing as chair, it's 11:10, this might be an appropriate time. And on the second point, if I may say, Advocate Johnson.
What's happening to you this morning?
I'm mixing up all my ranks and titles and everything. Advocate Johnson, insofar, I know it was your wish, you expressed it yesterday to finish by tea. If it's any consolation, my birthday was not too long ago. I reminded the commissioners I didn't get any gift. So it does happen.
So your gift will be to finish by lunchtime?
Yes, I have to.
Yes.
Have to finish by lunch.
That's why I was very cautious yesterday when you wanted to push for an undertaking that would be, and I refused. Please stick it out. It shouldn't be that long, Advocate Johnson. All right. Here's something I should say. In fact, I should have said when we started this morning, my ruling on the Karim postponement application is ready. Why I am not delivering it now or did not deliver it in the morning was because Mr. Karim's attorneys had not been advised. I gave an instruction to the Commission's attorneys to write to Mr. Karim's attorneys. So I will deliver the ruling at 2 p.m. before we commence. Let's come back at 11:45. Let's adjourn.
Thank you, Chair.
those together, they are all charged with
Good morning again. It's 11:44. We are ready to resume. Please make sure that your cell phones are on silent. Thank you.
Yes, Ms.
Thank you, Chair. Advocate Johnson, were you able to locate the preliminary report that you had hoped to locate during the tea adjournment?
That is correct, Chair. I have sent it to Mr. Maga to make sure that it goes through that.
That we receive it?
Yes.
Okay. Well, I'll await it. In the interim, your file 9 has been updated. You recall on that audit report, I indicated that it was availed to IDAC on the 26th of June. Now, it's a huge document. It's now added as CJC 398, starts from page 3534. And at paragraph 3, General Matlow states that her department, Internal Audit, Risk and Integrity Management, received a request from the Minister of Police on the 9th of January 2025. And that's what initiated this process. And as I indicated to you, the first 3 paragraphs are introductory. From paragraph 4, she goes into the detail of the documentation that was reviewed in the course of this internal audit. And it will run for 284 pages to our page 3817. And at 3817, she concludes, the above-mentioned transactions constitute corruption. On behalf of the South African Police Service, I would like corrective, remedial, and criminal action to be instituted in this regard. Then she's got the standard closing paragraph at 11, and there is my date of the 26th of June, 2024, which is when this affidavit was commissioned. You see that?
I see.
I had referenced it and I had said it does turn out that we ran into printing challenges, but during the course of the tea adjournment, they were overcome. And I thought to point out to you the basis for my conclusions. Thank you. Commissioners, unless there are further questions on this topic, I would like to move to the next. Thank you.
Sorry, Chair, if I may just inquire, then that preliminary report you will make available for the Commission so that they are able to deliberate it as a result of the engagements that were had, my not being here notwithstanding, because the purpose is to make sure that the Commission receives them.
Definitely, and in fact, I hope it comes before you leave the stand, because if it does, then we can formally place it on record as well,
yes,
and its date, and then the commissioners will consider its contents. In the context of the wording of the affidavit, Section 27 referral, I trust that there's an explanation as to why it's not referred to in the Section 27 referral, but IDAC has it, and that there is a way to clear any doubt in the Commissioner's mind that it followed subsequent to the initiation of the entire investigation by General Matlow. But we can only comment on that once we have had sight of it.
And just to indicate, I did procure it from General Matlow.
Noted.
Can I just
Yes.
clarify, especially if we are going to have sight of it after you're done, what are we looking for to see? Are we looking to see that she makes specific allegations against General Masemola and she states when it is that she informed him and that he delayed. Are you saying it will answer
Yes,
that?
and that there's an expansion of the offences, perhaps the other people, etc., but to your point as well.
Okay, thank you.
Thank you, Commissioner. Advocate Johnson, you recall yesterday Commissioner Khumalo asked you, he first made an observation and asked you a question, that there seems to be a hand in all this that we've spent the last 2 days discussing. And if memory serves me well, you denied. Now, my proposition to you is all that we've discussed about these investigations and aiming at the generals and the PKTT is wholly outside the mandate of IDAC as we understand it, as contemplated in terms of Section 7, 1 capital A. That's my assessment. And if you strongly deny that there is a hand in this, I would like you to explain to the commissioners on what basis, because this entire effort and exercise cannot have been to the benefit of IDAC. It's not to the benefit of the country to flout legislative prescripts in the manner that it would appear have been flouted by IDAC consistently and deliberately, and then to offer an explanation for why IDAC would conduct itself in such a manner, which conduct has the risk to destabilize the law enforcement environment and institutions. Thank you.
Chair, I did indicate yesterday, especially having been shown documents that I had not had sight of previously, if I can allude to perhaps two, is having a set of, if I get my days mixed, sorry, but having a set of 4 A1s taken by a person, Mr. Perama, then you have 4 A1s taken by Mr. Mansa, on a date when they are all supposed to have been together, executing one function together with the prosecutor. It's not for me to determine, I'm sure that exercise will still be done through your engagement, on which is the right set of affidavits, supplementary affidavits. That is one example. Closer towards the end of the day yesterday, I'm given a file, and in that file, we have the Public Service Commission report, dated 2023, Commissioner Khumalo, which I see for the first time. I only allude just to these two because they're very pointed and they're very factual in the nature of what is before us. I have had to ponder why we find ourselves in this position as IDAC, and why, while I accept, and I don't think that there's meanness when questions are posed by the Commission about, but why you didn't know, you should have read. I think the Commission understands I can't read everything and won't know everything, and I do have to trust and rely on my people. And I sat with a conundrum last night of why weren't these things brought to my attention? And if, especially with the Public Service Commission report, which is somewhat quite different, it should have stopped the day the report came in, because it should have been brought to the attention of the ID to say, ID, look, we thought we have a right to investigate this, but here it is. It has been done, findings had been made. that would have set that matter aside. That was not done. And now the question is why? Why wasn't I informed of the different statements? And what is the purpose then, chairs and commissioners, and forgive me if I'm rambling, but I have to think it out loud because it does not make sense. And I'm saying that there must then have been something else going on that I was not aware of. I cannot tell you what the something else was. I wish I could. I'm not therefore disagreeing with your counsel. I just needed to put it in a way that I am able to, unfortunately, not reconcile, but try and understand about what it is that was going on. You can't reconcile yourself with bad when at all times, I know that I made mistakes as the head of ID, non-intentional, and a lot of them are perhaps administrative things. But at no stage did I apply my mind in a way to seek to to vilify anyone. And so when you don't always have the full knowledge of things, I think the challenge I sit with commissioners is how will we as IDAC, IDAC will only be 2 years old on the 19th of August. And as a young institution, what will be the mechanisms that have to be put in place for these underlying hands, persons and personas not to have the kind of influence there seems to have been had. I'm unable to take it further than that.
What could the something, as you put it, possibly have been? Surely you must have your ideas. Because one could easily say it was improper motives. But I'm not necessarily suggesting that. I want your own thoughts. What could the something possibly have been?
The something, Commissioner, I take it also from my time at the DSO, the Scorpions as they were. A lot of the times, and history had shown that, you find that staff get overzealous in wanting to present their case. But more often than not, you find that they engage with persons outside the purview of the work we're supposed to do, and you are not privy to that engagement. Mm-hmm. And so the mind you expect them to bring to bear on the mandate and on the cases is what you're engaging them on. It has been a past experience. In the way things happened this past week, it seems that there are other actors that might have been engaged with for us to be where we are.
And when you talk about other actors, are you talking about undue influence, perhaps?
I don't want to put it so harshly without having any, but to say that persons might have, for motives known to them, cast certain narratives or provided certain information. And you find that without of necessity, because what you expect, everybody gives information. Lots of people like to say lots of things. Do you verify it? Do you consider the source? And do you ever stop to ask, why did that source come to you? It is a question I've had to ask in this very painful few days you've had with me on the Section 27 referral of Adams. How it came about, what was the purpose, and look at where we are today.
But you cannot seek to extricate yourself as you appear to try to from what happened especially with regard to what you just referred to, which is the Section 27 referral. That was there for you to see, and right from the first day, we took you through that document, and you agreed when I suggested to you that it had open quote, nothing, close quote. You accepted that when I so suggested to
Correct.
you. So you cannot seek to say others may have acted wrongly. I will say to you, you too acted wrongly. And if there are questions to be asked about why, those must relate to you as well.
Correct.
On a document or on an affidavit that had nothing except for factual conclusions, you acted. It had to be your decision, you as the head of IDAC. It had to be your decision, and indeed it was, for any investigation to have gone on in the first place. Cut a long story short, I do not understand why you would want to blame others.
If I may.
As it should have, the buck stopped with you. And indeed, from where I'm sitting, it did.
And that is why, as I was carrying on with the Adams matter, that brought starkly home, from start to finish, the
Yes.
responsibility across the board.
Yeah.
In the first two instances, there are different instances that I used, as I hadn't been aware of them. But I sit here today knowing that I have to take responsibility
Yes.
for all the actions that flowed, intentionally or unintentionally. And I will be judged for those actions.
Yes, but why I'm going back to where we started on the first day of your testimony is because in the context of blaming others, you are referring to the Section 27 affidavit. And it is in that context that I say you cannot blame others.
It is my responsibility.
It is and it was your responsibility.
I accept that, Chair.
Thank you.
Thank you, Chair. Thank you, Advocate Johnson. As I indicated, I would like to move to a different topic. I have a few small topics to cover with you quickly, and I hope we can wrap that up in an hour. We now have it wasn't a promise, but a new hope that you'll be done by lunch. I hope to at least deliver on that one. Okay. The next issue is, do you have your statement filed close by? And in particular, the first October 25 statement. And at page 10, paragraph 30, you indicate once the investigation was concluded, this is the investigation following Mr. Adams's Section 27 referral. Once that investigation was concluded, you say you were briefed by the team that had conducted the investigations on behalf of IDAC. IDAC then applied for warrants of arrest against the accused. I then prepared a prosecution memorandum and submitted same to the Director of Prosecutions together with a draft charge sheet and a request for the enrollment of the matter. Now that prosecution note, memorandum you prepared is in file 8, page 3256. If you could lay your hands on file 8. It starts at 3256. And at 3257, paragraph 11, you state Section 9.1 of the National Instruction 11/2017 states as follows: a selection panel may not be biased and must ensure that the selection process is free of nepotism or favoritism. A panel may never abuse its authority, and panel members may not influence each other to be influenced or to abuse their authority. So you're quoting from the National Instruction. At 12, you state, evidence collected proves that accused 1 to 6, these are the members, contravene the provisions of the above quoted sections to the benefit, I guess, of accused 7 without just or reasonable cause. In your paragraph 30, you indicated you were briefed. I take your use of the word at least implies engagement with the investigators to satisfy yourself that the charges suggested to be preferred against the accused have some factual and evidentiary basis. Is that a fair assumption on my part?
That is correct. The prosecutor would
Now,
also.
you stated paragraph 30, you prepared this prosecution memorandum, so you were armed with all that information. Are you able to quickly enumerate the basis on which you say the evidence points to the contravention of the provisions of that instruction by accused 1 to 6? What convinced you of the contravention? And at least, if we take the wording of Section 9 quoted, must show nepotism, it must show favoritism.
Sorry, I can't remember all the facts, except for what comes to mind, and I'm sorry if it's short.
No, accept, okay.
I think what comes to mind is that the selection panel tampered with the panel documents. The panel wasn't who they initially purported the panel to be. And when the investigation started, they had removed pages and inserted new pages, and that's what I recollect is in the docket. And there was an expert who does indicate that there was a tampering with that process, of the panel process, to misrepresent who in fact was the panel. And the only other thing I can recollect, and I don't mean to frustrate the commission, I haven't got the docket. The other thing that I can recollect is that there was a document created allegedly by one of the accused to give the impression that the process had been approved, but the person who should have authored that document was unaware that this document had been created and authored. It therefore gave credibility to the process and to the panel, which would not have happened had this not happened. And I think finally the only other thing I do remember is that there was fraud a fraudulent averment in the CV, which was deliberately not picked up so that a candidate could go through. But, sorry, Commissioner, that's the only ones that I can recall from my briefing with the prosecutors on that.
No, I'm happy with that, and in fairness to you, I'm asking you to recall off the top of your head, so I'll accept what you say. Just the panel, you say that the panel was changed. That's your understanding?
That's my understanding. And that apparently there's a document expert report that would show how pages were removed for a list of changed names to then be inserted.
Panel.
Yes, but I haven't read that report. But I'm aware that there is such a report.
Okay, I don't know if you are able to follow Colonel Padiachi's testimony, because insofar as the panel is concerned, we are not aware of such a claim. The only complaint would appear as reflected in an affidavit, in a statement provided by General Khan, that the only issue was that the panel did not include General Khan. But there was no suggestion otherwise of a manipulation of the panel. Are you aware of that testimony? That the complaint was that General Khan was excluded from that panel?
No, I'm talking about something completely different.
Okay.
That there was when they are, the way it was explained, when they are done with the documents, they have a way of stapling the documents so that no one can tamper with the documents. I think it's a police process for security reasons. And it was found that the documents, in the way they were bound, it was tampered with for an insertion of a different page. And the expert is able to say that the documents were tampered with and something else was inserted. How that is all legitimated, I'm unable to explain.
Now,
But that was different from what, what's his name? Mr. Padiachi. I'm not talking about that. I'm talking about something completely different.
Okay, and now this, and that insertion of this page, is that what reflects the manipulation with the panel,
Yes.
as you understand? Okay. The investigator and the docket does not suggest anything of the sort. I haven't come across it. I don't think anyone has in this commission. If the docket provided us is to be believed and accepted, but nonetheless, I'll leave it there. You proceed then at 3257, no, at 3258 to speak of the urgency. So if one has regard to 3257, pages 3257, 3258, would it be safe to assume that the charges against these accused would technically be for or revolve around the breach of Section 9 of the National Instruction and would involve nepotism and favoritism?
Correct.
The charge sheet is attached to your memo. It starts at 3260. What I find in the charge sheet are significant, I think, in respect of each charge, is extensive invocation, reference to an invocation of the provisions of the Prevention and Combating of Corrupt Activities Act 12 of 2004. Now, I'm trying to marry the content of your memorandum, which complains in large part of nepotism and favoritism, and trying to understand how that lends us into PRECA, because the charges they face are predominantly PRECA-related. In circumstances where the charges based on PRECA, including gratification and I think commission of crimes in the future, I don't find reflection in the original memo. How do I reconcile the two?
Sorry, for someone who wants to be out by lunchtime, I'm not reading very fast, am I?
It's okay, take your time. You haven't seen these in quite a while.
So for some of them, I see them on page 15.
Please reference the red number at the top.
This one.
You said page 15. I think you are looking at the typed page of that, whatever document.
No, it's got a black number.
Okay, the 3,000 and something top number. Are you in file 8?
So yeah.
Or are you working off your own copy?
I'm working on the chart sheet.
The charge sheet starts at file 83260.
3260. Okay. Sorry, I was in the.
Yes.
So the ones that I find relevant to the memo are on 3267. It would have been points
3267.
points 12 point 12.12, 12.13,
Okay.
12.14. We agreed about 12.15. I'm not going there.
So 12.15 is out.
Yes, I
Okay.
think Commissioner Khumalo and I dealt with that part of the gratification quite at length, so
Yes.
that falls away.
So 12.12 speaks of accused 7, and that is Mrs. Mkhwele, submitting false and misleading information in application and curriculum vitae. 12.13 is misrepresentations made by the accused with regards to the verting of accused number 7. And 12.14 speaks to accused 1, 2, 3, 4, 5, and 6 abusing authority vested in them by disregarding and not complying with SAP's national instruction. I'm still trying to get to PRECA. And based on the content of your own memorandum, because that memorandum, you recall, you submitted to the DPP.
So, at the time of the memorandum,
Yes.
we had worked on that which is in 12.15, talked about the gratification in the form of employment. But since we've had the conversation, that's what I'm saying to you falls away. It no longer finds place there.
But it's got a different problem because your memorandum doesn't even invoke PRECA at all. It speaks of no gratification. It speaks of nepotism and favoritism. That's the point I sought to make earlier. That if your memorandum is intended to inform and advise the DPP, the only instrument you invoke at your paragraph 11 is section 9 of the National Instruction 11 of 2017, which you quote verbatim, and that speaks to nepotism and favoritism.
Is it maybe, and this is the best that they can do, paragraph 14 of the prosecution memo? That's the only reference to gratification.
Yeah, that is quite correct. You see what Commissioner Kumalo helps you with, reference to 14, that's your gratification. Now, you say after engagement with the commission, you have accepted that the gratification can't stand. Now, cause of my difficulty is that the charge sheet is with you as you prepare this memorandum. And in fact, in the memorandum, you say the draft charge sheet is attached. And yet, I seem to pick up a disjunction between your memo and the eventual charge sheet. I thought maybe I'm misreading the memorandum, and you might be able to help.
The charge sheet, the memorandum is a summary, but the charge sheet is also attached so that the DPP is able to apply her mind to both the prosecution memo and the charge sheet. So where one may have missed something in the summary, she's fully within her right, as is always the case, to go through the charge sheet and to also raise questions about the charge sheet and or any deficiencies in the charge sheet.
You recall when, I think it was on the first day or the second, you explained that your referral of the charge sheet to the DPPU as the IDAC, it's not to seek the DPP's approval, but to inform the DPP in whose jurisdiction you intend to prosecute, that you are enrolling the matter. So it's an information sharing exercise.
No, but I say twofold. I did say twofold in the affidavit. I said twofold. It also is its own checks and balance that if there is anything, because the DPPs also have a right to ask questions and to engage the document. I did say that in the affidavit. They're not a rubber stamp, and I don't believe that that's the impression that was created, commissioners, in
Probably the error is mine. I might
So
have
I said
gotten a wrong impression.
Sorry, I said in the original affidavit was the first is the DPP is a measure for checks and balances. The second is so that the relevant DPP may grant permission for and or agree to the enrollment of the matter unless satisfied on the information given to him or her that there is reasonable and probable cause for the prosecution. The DPP will not place a matter on the roll for criminal cases. So it does give them latitude. They are not a rubber stamp.
I accept that. What is the purpose of a prosecution memorandum? It is to enable the DPP to precisely discharge the functions that you just enumerated, to enable them to make a decision. Do you consider your prosecution memorandum sufficient for that purpose? If the DPP would potentially read the two documents in the manner that I have and not see a correlation between the memorandum and the charge sheet. Because if they would, then they ought to have declined to prosecute on the basis that I don't understand where the charges, what the charges arrives from, because they are not covered in your prosecution memo. Am I being too pedantic?
I think counsel is entitled to her view.
Yes.
And I give respect to the colleague who went through this exercise, applied her mind, and was satisfied that based on the memo and the charge sheet, it was adequate.
The charge sheet is fully supported. Okay.
Yeah, I was going to ask, in fact, what it is that the DPP has. You give them the prosecution memo,
Yes,
and
ma'am.
then you give them the draft charge sheet.
Correct.
Is that all that they have?
That is all we give them.
So where a charge is about vetting, so I know we've had that conversation, but I want to use that as an example.
Okay.
That you have a count here which accuses Brigadier Mukwele in relation to her vetting position, and I think that's the very last count, where you say accused 6 acting in concert with accused 7. I'm looking at page 3279. It's the very last count, and it's just wanting to understand the conversation with Ms. So if you look at 3279, that's the very last count. And in there, you're describing what accused 6 and 7 have done. And then you say, accused 6 acting in concert with 7, unlawfully, falsely, and with intent to defraud, give out and misrepresent to the SAPS, National Treasury, the public, that accused 7's application for security vetting was registered on the e-vetting system when in truth and in fact, accused 7 application for security vetting was registered on the old Inkwazi system as a service provider. That's in the charge sheet. There's nothing about it in the prosecution memorandum, no detail whatsoever. And if all that the DPP has or had at the time was the memo and this draft charge sheet, how could they have properly exercised their mind to approve this particular charge, for example, because they have nothing else? And it seems Ms. Lo must be correct to say on this charge at least, the DPP should have said, no, we can't have that unless you give me more. You accept that?
I accept that.
Okay. So at least on this, I mean, I'm not talking about the others. On this, at least the DPP doesn't seem to have properly exercised their mind if all they had was your memo and the charge sheet.
Correct.
Okay, thank you.
It's the same with saying,
You wanted to say something?
Sorry, Commissioner Kumar. What I wanted to say is, in such matters, more often than not, and not just in these matters, in a lot of other matters, what we tend to do is we will send it to the DPP. We also do indicate kindly contact the prosecutor should you require clarity. And sometimes those conversations happen. I don't want to create the impression it happened here. I'm just saying there is room for engagement, and then they make up their mind. But there is also that process. I'm not saying that it did or didn't happen.
You don't have any, you're not suggesting here it happened because
No.
we don't have a record
We don't
of
have
that
a
happening.
record, yes.
Okay, thank you.
I was going to say, it's the same with the charge that in her CV, she misrepresented facts, but the charge sheet does not say what fact is misrepresented and what is the correct fact. And Commissioner Baloy's point that the DPP in file 62438, all he or she then says is that having considered your memo and the charge sheet, they are satisfied that a prima facie case has been made out against the accused, and they concur with your decision to charge them. So it means they only considered the two documents that Advocate Sillo and Commissioner Baloy are referring you to. And it's the following day. I mean, there wasn't even a week to consider and come back to you and say, where is this, where is that? What is inquasi, what is e-vetting? They seem to have rubber-stamped what was in the charge sheet, and there wasn't any engagement or consideration, because I doubt that any such engagement would have taken a day to finalize.
I accept that, Chair.
Thank you, Commissioners. Now, do you know when the decision was taken to prosecute the 7, had SAPS advised or sought to interdict the employment of Mrs. Mukwele? Was it suspended? Do you know what became of her?
No,
You're not aware?
no.
Having taken the decision to prosecute, did IDAC at least make a formal request to the National Commissioner to say we are proceeding with this prosecution and we have the applicant herself as accused 7, and we hold the position that her appointment is unlawful, and either suspend her start date until the criminal case is disposed of, anything, just to get her not to be in office, because you're suggesting that the appointment is tainted. Did IDAC take any such a step?
What IDAC does is we write up, I think the police call it a situational report after we have an arrest of any SAPS personnel across the board. We just give them a summary of the charges, who was charged, when they appear, and that then goes to the police. It is for the police to decide what steps they're going to take, but we have to put everybody in that was charged, not just one particular person. And then we escalate it to them for further action. Those are the kinds of reports I recall sending.
So the report itself doesn't even make a request for consideration by the powers that be within SAPS? Because if, considering the litany of sections of PRECA that you have invoked, this sounds like a grave, serious crime, and that in order to halt any adverse consequences flowing from that appointment, you at least would say, I urge you, National Commissioner, to consider suspending, giving effect to this appointment until the criminal case is done. You didn't, it doesn't
Not
go
for
that far.
Not for a specific individual. When it is sent on the understanding that the police will take whatever action, almost invariably disciplinary action, and they will decide against whom that action is taken.
Staying then with your memorandum at 3258, you have under item E, urgency. You say the case, at paragraph 17, page 3258, and you state the case relates to crimes involving dishonesty and abuse of authority that were committed against an organ of state, The allegations also affirm that the accused relate to state capture in that they sought, through their actions and in the furtherance of a common purpose, to circumvent systems and processes to unduly benefit another. I want to unpack that paragraph. I'm interested in the urgency. What was the urgency here? Because overleaf at recommendations 19, you state it is recommended that warrants of arrest of the persons involved in the commission of the offenses outlined in the draft sheet be obtained. So you were seeking these warrants of arrest as a matter of urgency. And the basis for the urgency, you set it out at paragraph 17. If Mrs. Mukwele was to take up her position at SAPS and precisely be involved in what IDAC fears, which is state capture and circumvention of systems and processes to unduly benefit her, what was the urgency in the arrest?
I don't know why it's got urgency there, because when you read the content, the content doesn't make anything, urgent.
It's your heading.
So I know it's my heading. I'm trying to figure out why the heading urgency, because the content doesn't talk to urgency.
I would have thought that the urgency is in the grave crimes that have been committed and the threat of state capture. At least that's how I read it. And if I'm correct in my reading, then the question is, how then do you allow that to take place by not at least stopping her assumption of office? But you are the author, and I do accept I may very well be misreading you.
Yeah, this notwithstanding, it's not our decision.
No, I hear that.
About her not taking office. Ours is merely to summarize what the allegations are, or the charges, and to escalate it to the office of the National Commissioner. Whether they act with urgency and or not, whether they act against all of them and or not, has nothing and should have nothing to do with IDAC, because that becomes an internal process that must be governed by themselves. And so if at the time, even when they received, and I cannot remember the date, even when they received the situational report from IDAC, they still sought, if she wasn't already in office, to put her in office or keep her in office. That would have been their choice.
Yes.
Yes.
And what you're doing is you're telling the DPP that to get an arrest warrant, because that's what this memo is about,
Yes.
is an urgent matter. So the question is, why was it urgent to get a warrant? Why was it urgent to get them arrested? Because that's what this memorandum is about.
I think for me, Commissioner Baloy, what does stand out in terms of memory is that it related to the abuse of authority that was committed against an organ of state, and that these arrests take place so that that abuse, alleged abuse, does not continue.
The abuse you're complaining about in your memorandum is they failed to comply with the instruction about employing this person. And you've explained that your briefing, your recollection, is you were told there had been manipulation of the panel of documents. So we're talking about, on this memorandum, you're talking about past activity, something that has been done and completed. you now want them to be arrested for that which you describe in paragraph 11 of your memorandum, because that's what you say is the problem. You want them to be arrested for non-compliance with that. And even your charge sheet speaks to past activity, except for that part where you say if she had been in office and continued to work, then she would have been doing, she would do what General Khumalo wanted her to do. That's the only future thing, but it's not in your memorandum. And working on the basis that your charge sheet, rather your urgent request for warrants of arrest and that they be arrested is connected to the breach of that national instruction. The question is, why is that matter that warranted that they be arrested or that a warrant is issued on an urgent basis? And it's not to say, we are not yet at the conversation about why arrest. It is, why was this urgent to do?
I just have that, Commissioner Baloy.
All right. I think I'm going to ask you a question about the arrest itself, but I just want to propose to you that this again, without in the absence of an explanation, it has appearances about it that the idea was to get them out of office, because once they are arrested, I mean, standard practice is when people are arrested and are presented before a court, they can never continue with their work. I think it's exceptional cases where people have been arrested and allowed to come back to work. But it seems this was the design, yet again. Arrest them, present them to court, then they won't be at work. That's my impression of what happened here. Do you want to comment before I ask you a question?
When they were arrested, I know you and I are going to have a technical discussion about what in office and out of office means. When they were arrested, they were not removed from SAPS. They were not able to go to the office, but they were still able to carry out their official functions. And I know technically, what's the use of carrying out your function in another place when you were supposed to be in one place? But if the motive was to remove them, then the ask would have been in that letter to the National Commissioner, when you're setting out the situational facts, they pose a risk and must be suspended immediately. And that was not done. We left it to the discretion of the police on how to deal with it.
Okay, that's a different discussion. We do know that there's a bail condition that says they must never go to the office. We do know from the documents that are before us that, in fact, at least General Khumalo, I don't remember the others, the National Commissioner put him somewhere else, right, in the meantime. Put him somewhere else until the issue of his bail was resolved, and then he brought him back to his substantive position. So there was an effect that came out of the fact of their arrest. There was a consequence to it. But my question, coming back to my question, why was it necessary to have them arrested? You could have summoned them, as you did with the National Commissioner, to come to court, as you've done in other cases. And I ask you this question because in the ad hoc committee, this topic came up, and you said that there was no risk of them fleeing and not presenting themselves to court. Why did you sign authority that they should be arrested?
So on a point of correction, I don't sign authority
No,
for them.
I misspoke.
Okay, sorry.
Why do you sign a request? Why do you make a request? Because that's the sole purpose, in fact, of this memorandum under the heading recommendation. It is recommended that warrants for arrest of the persons involved in the commission of the offences outlined in the draft charge sheet be obtained. So you are asking for warrants of arrest, and we know it's history now. We know you got that request. They were arrested. My question is, why, if you go to ad hoc committee and you say there was no need, there was never any risk that they would run off, and Colonel Pariachi accepted that they could have presented, you knew where they worked, you knew their addresses, why do you make that kind of request that they should be arrested? And you would have had the discussion, if you were following the evidence of Colonel Pariachi, you would have had the discussion about the least intrusive means being the first, should be the first preference of presenting a person at court, because the whole point of an arrest, if that power is not exercised maliciously, the whole point of an arrest is to make sure that a person appears in court. Here, on your own words in the ad hoc committee, you say there was no risk that they would run off. Colonel Pariachi accepts that you knew their addresses, you knew where to find them. Why does Advocate Johnson request an arrest and that these people should be arrested?
I know that at the time, even though it was not immediately in that time, that we had a lot of debates, and there were criticisms where we invited persons to hand themselves over. And we were seen to be selective when we asked people to hand themselves over. When we got the warrants of arrest, it was a method to secure their attendance. However, the manner in which their attendance was secured was we didn't go and arrest them where they were. I'm just explaining, I'm not saying that it makes it any better. The investigators called the different suspects, asked where they were, asked if they would hand themselves over, how much time they needed, told them where to come. And the actual execution of the arrest only took place then at the police station, and that was the means of then securing their attendance. But the process before that sought to be collegial and to ensure that they'll get to us as they get to us within the time frames they give us, that they should indicate what they need, that they contact their lawyers, etc. It wasn't, the process didn't seek to embarrass anyone.
It did, because with another witness previously, there were pictures that were circulated of General Khumalo in handcuffs. So there's no, and in fact, the very fact itself of an arrest is traumatic for any person. So you cannot sit there and seriously say, well, you know, because of how we did it, that mitigates anything. It doesn't. If you accept that as a matter of law and fact, there was no compelling reason to arrest these people, to bring them to court. If you accept that, then you must accept that it was a misuse of the power and discretion to arrest, because its sole purpose is to bring a person to court. And if you have other ways of bringing them to court, that must be the default. And that is a default that is not only about respecting human rights, but you know, we live in a society where you cannot infringe, you cannot breach the law, infringe human rights, take the most intrusive action and then say, well, at that time we were subject to criticism in other cases that we are selective. Then that's an admission that you used that process of bringing a person to court for a purpose other than what the law permits and prescribed should be used for. So you in fact concede in your long explanation that that power was used for a purpose that had nothing to do with ensuring that these people do come to court. What do you say to that?
I hear Commissioner Baloy's explanation, and I'm saying that is the route we followed.
Did they appear? Did they appear in
your
court?
argument
Okay.
that it was not, there are less intrusive means.
Yes,
that
and that
should
and
have
that,
been used.
Yes, and
I'm
that it
not-
was an abuse of that process that's
I'm not-
available to you.
I'm not taking it further than that.
You accept that?
I accept it.
Did they appear in court on the same day? Do you remember offhand?
I can't remember offhand. I'll have to check.
All right, but most importantly, it is you accept that in these circumstances, an arrest was not necessary. They could have been summoned to appear in court whenever you've eventually presented them to court, and there would have been no harm to the state's case.
I accept it.
You accept that? Thank you.
Thank you, Commissioner. On that score, then let's go. You recall you effected corrections and amendments to your original October 25 statement. And in that statement, you deal with the arrest of General Khumalo. We now have deleted the entire paragraph 14, and in fact 15, and replaced it with what you set out in your third statement at paragraphs 10.1 and 10.2. Your third statement, page 3. So we will work off the latest version. So your new paragraph 14 regarding General Khumalo's arrest, you state that Lieutenant General Khumalo was arrested after he had landed at Oliver Reginald Tambo International Airport, Otia. I do not recall where he was traveling from. I was informed that at the time his co-accused had already been invited to report to Brooklyn Police Station. If whoever the arresting officers were aware that he was traveling from somewhere to Joburg, why was he not given the courtesy like others to report to Brooklyn Police Station upon his arrival in Johannesburg? Why did it become necessary to go to set up a welcome party, a welcome delegation for him? Because you stated your new paragraph 15 then, the investigators went to Otia to inform General Khumalo that there was a warrant of his arrest and for him to hand himself over. But that doesn't make sense. They didn't go there to inform him so that he can walk himself to Brooklyn Police Station. They actually went there to arrest him. So basically what I suggest, in your new paragraph 14 and 15, you try and downplay the arrest by suggesting that as with his co-accused, he was invited to report to Brooklyn Police Station, and I'm saying it's not correct. Factually, we know that is not correct.
Sorry, Counsel, which part is not factually correct?
That they had gone to Otia to invite him, as they did with his co-accused,
Yes.
to report himself to Brooklyn Police Station.
But that is what they did.
No, they went to arrest him.
No, they called all of the accused.
Yes.
And sorry, they were not accused. Called all of the suspects and invited them to hand themselves over at Brooklyn.
Can you stop there? Was the same courtesy extended to Lieutenant General Khumalo?
That is what I understand. They went to...
That's not what you have in your
They
statement.
went to Otia to inform him that there is a warrant for his arrest, for him to hand himself over, and he then accompanied them to the Brooklyn
Okay.
Police Station.
Then I must accept that
the-
in respect of all six, this is time that's putting pressure. I accept that the arresting officers went to all their homes and offices and told them to please leave their offices and go to Brooklyn. It can only make sense in that manner. Because otherwise, I suggest, to invite them to report must be by means other than physically going to them. So you either call, send a message, send an email, some other form of communication. And my argument is, if IDAC was able to extend that courtesy to all other 6, did it do so in respect of Lieutenant General Khumalo, such that if he says, oh, I'm out of town, when are you coming in? I'm coming in this afternoon. As soon as you arrive, please present yourself to Brooklyn Police Station. That's all it took. But it doesn't sound like you did, or by you, I mean IDAC did.
The investigators would be best able to answer, only because they had that direct engagement with him and had the direct engagement with the rest of the accused.
But you have offered in your statement how they came to appear at Brooklyn Police Station.
Because I needed to account, and
Yes.
this is the account that I was given.
And so too must you accept that the purpose of going to Otia upon his arrival was not to inform him. I have a sneaky suspicion that he's got a telephone, he's got a cell phone, that somebody within IDAC, the number may have, including yourself, considering his seniority. And that was easy to call him, to send him a message, a WhatsApp, Signal, what is the other new one? The Swiss one, we learned something.
Okay, I don't know about the Swiss one, but
I learned.
I take your point.
Yes.
I take your point.
I'm saying, actually what you are stating, it's a rather misleading. They went at the airport to arrest him, period. They went there to arrest him. And by arresting, it doesn't mean they have to speak gruffly to him. They could be very well nice. But at that point, he no longer had an option to go anywhere but straight to Brooklyn Police Station. That in any language constitutes an arrest. Would you accept that?
I'm accepting your point.
Thank you. That now, as I understand, that was, I call it the first arrest, and not that there was a second, but I do so to distinguish it from what I call the aborted arrest, the one of June 18th. Yes, June 18th, 2020. Yeah, thank you. Now, the one of June 18th is in respect of docket 543/06/26, the second docket. Now, it was not that arrest or application for those warrants. They were not in any manner prompted by the arrest of Mr. Fadiel Adams by the PKTT. No, there is no connection between the two.
No.
Okay. Did you ever have a conversation with DPP Advocate Harrison from KZN regarding Mr. Adams's arrest, whether impending arrest, issue of arrest warrant, or his actual arrest? Did you ever have a conversation, whether it's orally, by WhatsApp, email, whatsoever? Did you have any communication with DPP Harrison regarding Mr. Adams's arrest?
I did. I also think I wrote her a letter. The gist of the conversation was just to indicate, I'm not sure if you are aware that Mr. Adams is a witness and in an IDAC matter. And I just wanted to know whether or not he's going to be arrested, just so that we know how to handle him, because we are one NPA. It's actually in a letter, and I think it's best that I make that letter available.
Yes, please.
I was already told I'm overdue in my office, so I'm going to go there when I have time this afternoon, and hopefully still have access to the emails. I did write her a letter, and I made it very clear in the letter, and I think that is why it's important the Commission get the letter. I said, I do not want, I surmise, but I said, I do not want her at any stage to think that IDAC is indicating that he should not be arrested if he committed a crime. I just thought that because it was open knowledge that he was a witness to IDAC, just give us a heads up, because witnesses become difficult and they become difficult to manage. It is on that basis and that basis alone. And the letter is very clear about that.
Yes. But why do you address that inquiry to the DPP and not to the agency arresting him, the PKTT? What does the DPP have to do with that? How would she potentially assist you?
The DPP would then be able to, when we write, we engage in that way. I write to the DPP. If she wanted to know something that was happening in Pretoria, she would write to the DPP in Pretoria, and the DPP goes ahead and finds out if there is such a matter and who's dealing with the matter and what the matter is about. And the DPP was able to find out and indicated not the details, but that they were looking at a matter, there was a criminal matter, and we left it at that. We did not engage again. And after that, we did see the arrest as it happened.
I still don't understand how she would assist you, because at that time, if she would have been involved in any manner, might have been by authorizing the issue of the J50s. So as I think of things, that's the only issue you'd have been talking to her about. But to find out why this person is arrested, you are directing the query to a wrong person. It should be to the agency that arrested him, which is the PKTT. Are you sure you are not engaging here to find out who authorized those J50s?
No.
Okay.
She didn't indicate that there were any J50s at the time either. There was nothing to engage about the J50s. Council.
Okay. Because I'm still at a loss as to why you could potentially call the DPP following an arrest of a suspect in a matter that is not on your table.
It wasn't following the arrest.
Oh, regarding, I agree. Regarding the arrest, whether it was before, during, or after. I don't see it. I correct myself. I take your correction.
So because we've had challenges in other matters where an agency arrests a witness.
The DPP did not arrest him.
An agency arrests a witness in another matter, and that matter becomes prejudiced because the witness now no longer wants to testify in a matter where there had been a witness for quite some time and want to know from you, the team for whom they are going to be testifying, why didn't I know I was going to be arrested? We don't know all their cases. What it is it becomes a bit difficult to manage the relationship. And so within the NPA, we have undertaken to at least inform one another. No dictate, is to just indicate the person you arrested is my witness, and that is it. And that is where we've taken it, and that is where we leave it.
Okay.
It's not the first matter.
I guess my challenge is I don't see how a conversation with the DPP would go where you say to the DPP, the person you arrested, because the DPP didn't arrest that person. So how that conversation even starts to land where you suggest it did, I can't wrap my mind around, but you know, I'll catch up. It's exhaustion perhaps. Okay. We have reached our crisis point, which is that it's 13:02.
And I can hear the chair whispering there. He says, Johnson, you can go home, girl.
Did you hear me whisper back to him, no, Chair, she can't as yet?
No, and Commissioner Baloy says, no, you don't get to do that, Chair.
Always full.
Silo, how much longer do you think we're going to be? I'm asking because we could continue and have a late lunch.
Okay. Yes, we could. May I not attach a time because I don't think I've kept to any that I've previously offered. But, okay, I have 3 little matters to
No, when
address.
you do them like this, they don't look little to me at all.
No, what's remaining, I promise you, they're very little.
It's a bit intimidating when she says 3 little.
Perhaps let's take the lunch agenda
Okay.
and
Chair, may I
resume.
ask, I know you had an engagement already at lunchtime for a judgment. Will we come back finish this and then you proceed with the judgment, or you'd have us wait out?
Let me straight away say it will just be the ruling with no reasons. So.
We'll be back.
You should rather either sit there or sit anywhere but inside so that we start immediately.
Thank you.
Thank you, Chair.
Let's adjourn and resume at 2 p.m.
All right, it's 13:59. We are ready to resume. Please make sure that your cell phones are quiet. Thank you.
The ruling I'm going to make is in relation to the postponement application of Mr. Karim. Having considered all the papers filed and oral argument presented by both sides, I make the following ruling. 1, the hearing of Mr. Karim's evidence is postponed to 14 August 2026 at 9:30 in the morning, at which hearing Mr. Karim shall be required to appear and testify in person, subject to paragraph 2. 2, Mr. Karim will be excused from appearing on 14 August 2026 only if 2.1, he has voluntarily subjected himself to an independent evaluation by a medical specialist agreed by no later than Monday, 3 August 2026, between his representatives and the Commission's evidence leaders. And 2.2, such independent medical professional has provided a medical report to the Commission by no later than 12 August 2026, confirming Mr. Karim's inability to testify on 14 August 2026. 3, failing the agreement envisaged in 2.1, the independent evaluation and report envisaged in paragraph 2.2 shall be performed by an independent medical professional nominated by the chairperson of the Association of Medical Professionals, in the field of medicine in which Mr. Karim's current doctor practices. 4, the reasons for the ruling will be issued at a later stage. I hand down the ruling. As usual, the ruling will be uploaded onto the Commission's website. Thank you.
Thank you, Chair. Advocate Johnson, you recall before we broke for lunch, you indicated that there was a preliminary internal audit report that had been availed. I confirm a document has been availed to the Commission. Commissioners, you have run out of space in file 9, so it's a little file marked Exhibit File 9, capital A. And it should have been put on your desk. Yeah. Advocate Johnson, you have it before you?
I do, ma'am.
It's marked for record purposes CJC 399 and starts at 3818. I've just received this and I just quickly scanned it. You recall that you indicated that it was received at the same time as the General Matlou Section 27.
That is what she informed
That's
me.
what you are informed. And I looked through this, so if we could just flip, and the purpose really was to see the extent to which that Section 27 even implicates General Masomula. Looking at it, I see that it gives a background to the bid itself, and at page 3823, it is signed 29 April 2025, at the bottom there. And if we go beyond that, it seems to have an annexure. and addresses at 3824, accountability, responsibility, and distribution. It kicks off with a detailed analysis of the bidding process, and it gives all those details, the bid evaluation, and at 3838, it then makes certain observations regarding red flags and or evidence of fronting in the bid of Medicare 2420, sets out the basis for concluding there were red flags, then addresses at 3839 the various companies registered to Mr. Nhlanhla, at 3840 registered to Mr. Van Wyk, as well as other 12 companies registered to Mr. James George Murray. Then at 3841, it makes general findings at paragraph 3.4. And they are set out there, but the interesting thing is that the conclusion 3.7, it concludes the bid adjudication committee did not exercise due care in considering an evaluation report from the bid evaluation committee. Then it draws conclusions at 4. At 5, recommendations 5.1.2, the recommendation is that the bid should be terminated. The accounting officer should seek legal counsel on how to proceed with termination. The termination of the bid is consistent with section 23.1C of the general condition of contract, which states that the purchaser, without prejudice to any other remedy for breach of contract, by written notice of default sent to the supplier, may terminate. At overleaf at 3843, it states evidence 5.1.3, evidence of procurement irregularities were observed in the bid. Therefore, the bid is currently being subjected to a forensic investigation with a view of pursuing a criminal investigation against the supplier. So, and that seems to be the conclusion. So we know this is the preliminary report is available on the 25th of April, 2025. And in terms of...
Sorry, Ms. Where do we see the 25th?
Me?
Where do we see the 25th?
Oh,
date?
that is at...
It's on the second page, Commissioner Baloy, I think it's, yeah.
Second page of the report.
It's 3823.
It's also there.
Oh,
It's signed and dated.
yes, thank you.
Yes, by the Acting Chief Audit Executive T.E. Mkhwana and by Chief Risk Officer Major General Matlow. In fact, it's the 29th of April. 29th of April, 2025. And we know from General Matlow's Section 27 referral that by the 15th of May, General Masemola had terminated that contract.
So 2 weeks later. 2 weeks after this report, General Masemola had terminated the contract.
I get it, Chair.
And remember, as Advocate Sillo said, 5.1.2 said he must seek legal counsel on how to proceed. So one must assume that in those 2 weeks, he sought legal counsel.
That is correct.
Thank you, Commissioner. So, and I know I read it very carefully. Where I land is, insofar as General Masemola is concerned, it doesn't cure the shortcomings in the Section 27 affidavit as submitted by General Matlow, because it is absolutely silent on either irregular conduct, unlawful conduct, criminality attributable to General Masemola. Is that your... And I know perhaps you only had an hour as well to go through it. Is that your interpretation as well?
From the
From the
preliminary,
document
yes.
itself? Yes. Then I think that then settles the matter. And it goes back to the concession you refuse to give me, and you say it's dependent on the contents of this document. You've seen the document now. Are you going to agree with me? You said it would be irresponsible, I think, to agree with me without having had sight of the preliminary, the interim audit report you have now had sight of. So on the basis that the condition has been met, I take it won't be irresponsible to agree with my conclusions.
Let me think. We didn't finish before lunch, so maybe I'm still disagreeable. No, I agree.
Thank you.
I agree.
We had just dealt with the arrest and second intended arrest that didn't take place of General Masemola. I would like to move on. Yes, we are closing 9A. Thank you, Commissioner. Chair and Commissioners are suggesting that I move on from the issue of the arrest of General Masemola and the intended arrest for June 18th, 2026, which was not executed.
Sorry, it's Kumalo and Madondo.
What did I say? I said Masemola.
Masemola.
I'm getting everything wrong today, ain't I? I just, my apologies. There was never an intended arrest for General Masemola, General Kumalo, and General Madondo. Advocate Johnson, a document will be distributed to you. Don't mind it for the moment. We'll refer to it when the time comes, and we'll have a discussion on it. I then want to move. Are you aware that after the arrest, yes, you are. After the arrest, the accused applied for bail in the magistrate court, and they were granted bail. You are aware of that.
Which matter are we talking about?
Oh, in the Mugwele matter.
Correct.
Yes. And if you turn to, I think it's, if you bear with me, file 7, page 381. Page 3, no. CJC 381, page 2948. Apologies, Commissioner. It's CJC 381, page 2948. Those are the magistrate's notes taken during the bail hearing. Are you aware of the condition granted, bail condition granted by the magistrate at 2949? It's condition 3. That accused number 1, 3, 4, 5, 6, and 7 are prohibited from being at any premises of crime intelligence within the country, RSA, while the matter is pending. The fourth condition was Mr. Brian Padiachi will assist the accused with the collection of any matters or items of personal nature the accused may have at the premises, in the crime intelligence officers. I don't see everything there, but that's the gist of the fourth condition.
May have left.
Or may have left, thank you, Chair. May have left at the premises of any crime intelligence office. Now, you were asked about this condition at the ad hoc committee, you recall?
I must have been.
Let me see if my record keeping is what it ought to be.
3.
I've lost my place, but
Are you perhaps looking for page 543? It might give you a sense of where you're trying to go.
could very well be, Commissioner. Yes, it's page 543, thank you. Thank you. And it starts at 542 at the bottom. And at the bottom, Advocate Arendse, referencing some of the complaints by Lieutenant General Mkhwanazi at the press conference of the 6th of July, 2025, states, now he being referenced to General Mkhwanazi, makes reference to one of your investigators, Mr. Brian Padiache. Let me put to you 2 allegations made by Lieutenant General Mkhwanazi made in his affidavit. He said, quote, a further condition is that the accused required anything, if the accused required anything related to their work, it could only be obtained through the intervention of the investigating officer. This is in relation to General Khumalo. Then at the bottom of 342, it indicates that General Khumalo has applied for the bail conditions to be amended, but the hearing of this application to amend has been postponed on numerous occasions. Then you respond to this bail condition at page 543, and you state the assertion being that Mr. Padiache would be allowed to have access to criminal intelligence is incorrectly interpreted, mainly because we have witnesses at CI. Those witnesses had indicated that they had been intimidated and victimized. The condition for them not going to CI was to ensure that the witnesses were not intimidated. Mr. Padiache would not have been allowed to access any documents from CI. If after that one identified that there were documents from CI, we would have had to follow the process we had followed initially, which would have been to issue a Section 28 subpoena to the National Police Commissioner. No one would have been allowed to go to CI, engage any personnel, or take any documents. It is Mr. Padiache who, in fact, would call Lieutenant General Mkhwanazi to let him know that he's going to be in the province. There are a lot of points raised in your response. I will, for the moment, not deal with the issue of Lieutenant General Mkhwanazi and Mr. Padiache having to call him, because I don't understand what he's got to do with this particular bail condition. I'm interested, and the point you make that it would be wholly wrong to have a condition that entitles Mr. Padiache to access to CI documents. That was your view, correct?
Yes.
Are you aware that when the Lieutenant General Khumalo, I think there were 3 of them who challenged this condition, that Colonel Padiache filed an affidavit in opposition of the amendment of that condition in circumstances where you, as his leader, knows that that condition would not make sense because Mr. Brian Padiache himself does not have any security clearance to access information that is within the CI offices.
Correct.
What's your comment to that?
So, first of all, and that is why I said what I did at ad hoc. We have no right to enter those premises. And if, as per the bail condition number 3, that bail condition was way too wide because it talked about crime intelligence within the country. These were crime intelligence officials chair at head office. So, and the purpose for which I understood they were going to ask for that condition was merely based on the fact that there were witnesses still employed within crime intelligence and that these witnesses feared any of the accused coming back. That part made sense, but not the bar them from every crime intelligence office in the country. And that the only role that Mr. Padiachi was to play was to accompany them. They would take what they needed to take for whatever reason they needed it. That is how I understood the condition was supposed to work.
Well, I guess that might be because you had discussed it in the office. Are you aware that such a condition was not even sought by the prosecutor? Even a watered-down version, as you put it, that they be allowed to go into CI offices but accompanied by Mr. Padiachi. Even that was never sought.
Sorry, Counsel, I don't follow. If the prosecutors didn't ask, who made this condition?
Sorry, say that again?
Sorry, I didn't follow. If
no, I missed your last point.
That
Please repeat.
You say that the conditions were not sought by the prosecutors. Who sought, then how would these conditions be imposed? Because, and please, I don't mean to be condescending.
Yeah.
As a career prosecutor, we always stand up and we ask. We will suggest bail, whether we oppose bail, we'll agree to bail, and the court will ask, are there conditions? And then we say, yes, and we've either agreed to the conditions or there's no agreement, but these are the conditions. You have to give the conditions to the presiding officer who must either accept, reject, engage, and then conditions are set. So that is the purpose of my question, Counsel. I'm not doubting what, I'm trying to understand, how do we have conditions then?
Well, that's exactly what we were trying to understand, and we put the question to Colonel Padiachi. His explanation was he can't testify to that because I think by the time the prosecutor finished her address to court as regards the bail conditions, he had since left court. Alternatively, that maybe the magistrate overheard him and the prosecutor conferring in a corner, and without it being requested in open court, the magistrate then decided to add that condition. That's his explanation. Please don't ask me as to the logic of it.
I have to disagree.
Yes.
And the prosecutor, Mayor Joy Hlachwayo, is an experienced prosecutor. She's not going to be standing in some corner having a chit-chat with whoever. If there were conditions to be asked, she would have asked them. So the fact that he walked out of court should not cast aspersions on anyone in there. I am of the firm belief that, and I do not know this magistrate, I am of the firm belief that the prosecutor would have had to ask for these conditions and they were then endorsed by the court. I do recall, Commissioner Baloy, that I think everyone was flustered after his testimony. I just don't have it. I will ask someone to get it. There was a video clip where Advocate Hlachwayo Joy was addressing the court and asking for conditions. And even when the court, I can't remember all the conditions that were being asked, but she was addressing the court. And at a stage, the court then asked, but who is the investigator? And she is the one who said, it is a Mr. Padiachi or a Mr. Brian Padiachi.
Yes.
That is what I took from that clip, not having my own personal knowledge. So I do not agree that even if he left, that I can't dispute, But a magistrate would not just endorse that which is not asked. It's just out of practice. I find that highly unlikely.
I agree with you. I fully agree with you. See, that is the most striking part of this condition. Firstly, we do have a clip of the prosecutor addressing the court, and we hear all her complete address and engagement with the magistrate until she finishes. And nope, it's a longish clip. We don't have the time to play it. We can avail it to you. You'll watch it at your leisure. Firstly, during that particular address, which I understood to be the application, which is the application for bail, Mr. Padiachi is visible behind her at all times.
Yes.
So I don't know which point he left, but that was his testimony. That is the first. Second, on listening to that clip, nowhere is a condition in the terms expressed ever requested by the prosecutor. The only term was, the only engagement they seem to have is about protection of witnesses, to which the magistrate asks about who the witnesses are, and the response is that they are not ready to reveal the names. There was an engagement about their safety and concern, and the magistrate was assured that that is not an issue, it's not a problem, because they are not even known. So let's not conflate the condition regarding the security of witnesses with access to their CI documents and material.
Correct.
But somewhere, somehow, the magistrates end with that condition, and specifically nominates Mr. Brian Padiachi as the go-between between the accused and their material in their offices. So, the questions you're asking yourself, I thought that I had hoped you might be able to shed light, because Mr. Padiachi's excuse is that he probably had left court by the time the condition was discussed. We see from the clip he never left court. That then brings to the fore the question again, where does the magistrate get this condition from if it was not a matter ventilated in open court?
Had to have been ventilated in open court.
But it wasn't.
Sorry.
Maybe to be of assistance, you could look at 2956. This is the judgment, the appeal judgment. If you haven't seen it before, it sets out the exchange in court. The judge in the appeal sets out the exchange on this issue of bail and the condition. And none of it indicates that the prosecutor asked for this bail condition.
If I may, Advocate Johnson,
Sure.
I think it might be helpful for you to jump to 2959, that is the judgment, under paragraph 19, where the judge, the High Court judge, then analyzes the appeal.
Before you get there, 18.3, where both counsel agree that the court did not seek submissions from them about the condition it intended.
I think that 18.3 wraps it up.
I see that.
And then the judge considers the appeal at 19.3, points out that the legal issue to determine in these bail, in these proceedings, namely whether the magistrate erred in imposing the bail condition, must be assessed based on the material that was before him and the way he dealt with that information or evidence. And then from page 2960, he references applicable legal principles. And he concludes that at 2962, at paragraph 19.17, I'm unable to find any judicial basis on the evidence and submissions before the court quo for the bail condition that was imposed. In exercising his judicial discretion, the magistrate did not confine his assessment to the facts presented before the court.
It seems from your discussion with Ms. Sello that you were not aware that the prosecutor did not ask for this bail condition. Am I correct? Yes. How does it work? You would have received a report back. No? Is that not how it works? Because this is a big case. So I think, and correct me if I'm wrong, I assume because it's not a run-of-the-mill case, because of the personalities involved in the organization that is involved, it's playing out in the media. So you would have been getting reports even after court. Firstly, I would have thought when they go to court, there's been an internal discussion about this is the position we take about bail. And
The prosecutors and investigators would have, yes.
You are not part of that discussion. But when they come back, you must get a report back about what happened. Does it mean that the prosecutor and the investigator did not disclose to you that they got the bonus of a condition that was not asked for?
From my recollection, Commissioner Baloy, the condition that I recollect is that the accused, they raised the issue of the witnesses and that the witnesses being at head office and that there was a condition that the accused would not be allowed to go to head office and that should they want to go there, they would contact Mr. Padiachi. And that was it, because of the witnesses.
Yeah.
That was the feedback.
You see, if they told you, both of them, if they told you that the names of witnesses were raised in court, that's false. Because in fact, the exchange between the magistrate and the prosecutor specifically says, the accused do not know who the witnesses are. As the magistrate says, but how do you protect witnesses? And the prosecutor says, I have no concern about that. Because we have not disclosed their names, and we are not going to disclose their names because these accused face other charges to which these witnesses are of assistance. So the names were never raised in court. And if that's a report that you got, it would be most disappointing that a prosecutor would give you that kind of report when in fact it did not happen in court. At the very least, it's disappointing. Had you known that this is a bail condition that was not asked for, what would you have done about it? Had Miss, I think you said it's Prosecutor Hlachwayo, I think
Yes.
that's her name. Had she done what I think every officer of the court has a duty to do, is if things have happened that should not have happened, in fairness to the accused, as your code of conduct says, that prosecutors must be fair to accused people as well. If she had done what a prosecutor is required to do, or an officer of the court, which is come back to you and say, I didn't get the chance to correct the magistrate for whatever reason, but we got this bail condition and we didn't ask for it and I don't know what happened.
Then they have to go back to court,
Yes.
recall the matter,
Yes.
and indicate afresh which could have happened the very next day.
Yes.
What the conditions were that the state requested,
Okay.
and that there were in fact conditions they did not request, and that the bail conditions be accordingly amended to reflect only what the state asked them
Okay.
for.
And it takes me to a question that I was going to ask you, which is, on what basis do you oppose the appeal? We know there's an appeal. You oppose, in fact, it starts off with you in the ad hoc committee saying that bail condition was obtained to protect witnesses.
Yes,
We know that's false. That it
It
wasn't
is
asked for.
that small one that I
Yes.
understood, yes.
Yes, so we know that's incorrect now. You now know that, if you didn't know it before. My question was going to be to you, you oppose the bail appeal on a condition that in fact was never asked for, and the magistrate and the prosecutor in fact must explain how they got there, how the magistrate got there and why the prosecutor did not correct it. And you oppose it. On what basis do you proceed to make the decision to oppose the appeal? And maybe let me ask you to be fair to you, had you known these facts that we've now put to you, that this condition, at best, the magistrate made it up for himself?
It's a very amplified, sorry, I interrupted you.
No, I'm saying, let me actually ask you a much more fair question. Had you known these facts now that I've just shared with you, with the appeal, what would have been your posture to the appeal?
There wouldn't have to be an appeal. There would have been the exercise I earlier indicated. The prosecutors would have had to go back to the same magistrate at the lower court and indicate that there's an imposition of a condition not either in line with what we asked or not what we asked at all. And we hereby request that bail condition be amended, because bail conditions and bail always go back to the court of first instance.
Yes.
He was the court of first instance, and so it makes sense to go there. And that is why I say that in terms of my knowledge, it was a very limited, and that is why, as I read here, I didn't understand why they couldn't go to any crime intelligence office in the country. It was just that office where there were witnesses.
Yes.
And just even on that, one should have gone ahead and said, but we cannot preclude them from every other office, but it is in this office where the witnesses are,
Okay.
that we were asking for their exclusion from the office.
Lastly, can I assume, am I correct to assume that had you known these facts, you would not have opposed the recusal of the magistrate?
Correct.
Okay, thank you.
Thank you, Commissioners. And I accept what you say, and particularly what you say ought to have been the right approach to the issue of the removal of that condition. But what actually happened is the contrary. IDAC, through Mr. Badiachi and perhaps the prosecutor, actively opposed the amendment to an extent that if we go to file 8, and at file 8, if we go to page 3028,
Three zero.
28. That should be an affidavit of Mr. Brian Badiachi. I located it. If you go to 3029, paragraph 5, Mr. Badiachi explains the purpose of this affidavit is to inform the Honorable Court why it is not in the interest of justice to amend the bail conditions of accused 3. The confidential documents referred to herein have been declassified by the National Commission of Subs for purposes of enabling IDAC to conduct its criminal investigations and where necessary to institute criminal proceedings pursuant to these criminal investigations. Let's move on to page 3030, paragraph 7.2. Mr. Padiache states, accused 3 is still gainfully employed as the National Commissioner has reposted her. She does not have a top secret clearance security. She does not have a top secret security clearance, which is a requirement for her to be employed as a senior manager in the Crime Intelligence Division. I'm convinced that any other tangible vetting, investigation, and processes will not change the prevailing findings that she is dishonest and has the propensity to commit criminal offenses, as evidenced by her own affidavits, which are attached to Banda's affidavit. Paragraph 8, the rationale for accused 3's application before the court raises important and relevant questions. The first being why accused 3, who is accused of committing serious offenses within a specific workplace, wants to return to the same workplace where many of the witnesses are based and therefore she has been exonerated, or it's a question. The second question is why does she want to return to the Division Crime Intelligence when she is fully aware that she does not have the requisite top secret security clearance to manage a very sensitive operational section of the Division Crime Intelligence at national level. He concludes over leaf at 3031, paragraph 10, and read midway. I am of the view that there is no exceptional or compelling needs or circumstances for her to return to crime intelligence. He's mounting quite a ferocious war to protect a condition that was never requested by IDAC, not requested by the prosecutor, at least in open court, and goes so far as paragraph 7.2 shows that his view is it should not be amended in respect of accused number 3, and for our record, accused 3 is Mr. Josias Ligalakala. That's accused 3, and says, no, I might be wrong. That is applicant 3. This is Madondo. And says, it's accused 3 in the charge sheet, that she has a propensity to commit criminal offenses. That's, okay. As if that was not enough, if you go to page 2985, same file. That is the affidavit of Charity Matlala Matlou. Yes, she is the Chief Risk Officer. You recall we came across her Section 27 affidavit in the SAPS Medicare contract. And she, at 2986 paragraph 8, she speaks of General Madondo's rank as Major General and employed as a member of senior management. She should have a top secret security clearance. The fact that no action was taken by Divisional Commissioner Lieutenant General Khumalo since 2024 February raises serious concern, as Madondo's mere presence in the Division Crime Intelligence poses a serious security risk to crime intelligence and the subs. By virtue of the case which Madondo is facing, I'm at 9, most of the state witnesses would be from crime intelligence environment. Her access being granted to the same environment increases the likelihood of witnesses being influenced or intimidated. And at 10, she concludes, there is therefore no compelling need or circumstance for her to return to crime intelligence, especially with the knowledge that her repeated applications for a top secret clearance have been denied. I suspect that Madondo has an ulterior motive for wanting to be authorized by the court to return to crime intelligence environment. Now, This resistance to an amendment of that condition has invited Mr. Padiache, General, what's her name, Matlo, to seriously impugn General Madondo's integrity, and by throwing wanton claims against her and accusations. That's the first. Second, these were filed in opposition of an application. This tells me that IDAC put up a formidable fight which would have required both human resources and financial resources. But it also had an impact in that the applicants who were seeking to amend the very condition had to obtain presumably legal services in order to have that condition amended. And all this is happening in circumstances where it ought not to have been there in the first place. I know you've left IDAC. If you learned what you learned today about what Mr. Padiache did, and perhaps others, I don't know, but at least we know his name is there and is quite active. Is there any action you would suggest be taken against Mr. Padiache? If so, what kind of action? I mean, clearly he's gone to SAPS to go solicit an affidavit from General Matlo. I don't know what she has to do with these issues, but he got it. There might be others that he also solicited to go resist that application. Now, is that not abuse, honestly? Is it not?
Out of my own personal experience, Chair, when we do decide to go to court after bail has, even the state when we want to bring in a bail appeal, we can only go, as I know the law, and maybe someone else changed the law in the meantime, we are only able to go ahead and appeal on the bail record. That's it. If there are certain aspects, be they legal or factual, personal, mitigating or aggravating, that were never part of the record, you cannot bring in anything new. And you cannot bring in anything emotive. The only thing we are supposed to have told any court, higher than the quota quo, is the quota quo erred for the following reasons, but it must have erred on the reasons as already espoused to in the lower court. These things, I'm assuming, were not said in the bail affidavit in the lower court. I would assume, and I hope I'm correct, that General Matlo also did not depose to anything in the lower court. So the action in which this part is taken is both excessive, unnecessary, and beyond the scope of what the bail appeal allows us to do. It is very prescriptive. I did learn in my young days once, I took a chance, because I didn't know any better. And the judge told me very nicely, which record did you read? Because in the one I read, the thing you're telling me is not in there. And you learn very quickly to confine yourselves, Chair. So, you used the word.
A different point about it, for your comment, the affidavit of General Madondo, it doesn't seem to even speak to anything that would be relevant, even if it were permissible. I mean, she's not alleging facts. She says she works in crime intelligence, she has a propensity to be dishonest, she doesn't have security clearance. That has nothing to do with this appeal. Am I correct?
Before you answer, a correction, I too hear errors. It's the affidavit of General Matlo, not Madondo. But it's about General Madondo.
Yes, thank you. Thank you, Ms. Thank you. The affidavit of General Matlo, I'm looking from paragraph 6, the kind of material, the kind of things that she's speaking to. It's all about a security vetting panel. Among the documents in the security vetting file, I note that she has 3 affidavits, and then 8, 9, pretty much nothing. And then there's a fear that she will interfere with witnesses, but nothing that says we have witnessed so-and-so, and this is the access she has to them. So it's truly, truly irrelevant, other than to create atmosphere in the appeal.
Yes, and if one wanted to say propensity to commit crime, it ought to have been raised in the lower court.
Yes.
That she did, in fact, commit crime. Yes. What were those crimes, and were they then relevant to
Yes.
the adjudication of the matter as it was in the lower court? Using the word propensity must have a basis. A crime must have been committed, relevant to.
Yeah. So it is a relevant question, or necessary question that you not for you to answer, but what interest did she have to file this kind of affidavit, opposing a bail application where she's not involved whatsoever in a matter, and here colluding with Colonel Padiachi, because he says pretty much the same things which have nothing to do with the bail appeal. So the picture that emerges is General Matlo married in quotes, to Colonel Padiachi's cause in opposing this bail application. And whoever approved that Colonel Padiachi opposed this bail application. Do you accept that's a fair assessment?
I do.
Okay.
And
Thank
this
you.
is not the Medicare matter, so I would have understood differently.
Yes,
If she had an input in the Medicare matter.
absolutely. Thank you.
Thank you, Commissioner Baloy, and thank you. Advocate Johnson, I agree with you. There is another small problem, I think. It goes back to your signing documents based on what your investigators tell you. On the 30th of June 2025, you penned, signed, and addressed a letter to the National Commissioner informing him that General Lushaba, General Kumalo, General Madondo, it's going to be projected here, General Lekalakala and General Gabela, as well as Ngube, I apologize, I don't remember her rank, and Brigadier Mukwele. You state, and this, it's, if you go to the bottom, it's signed by you, it's dated the 30th of June 2025, and at the 4th paragraph thereof, you state, kindly note that none of the above named officers are allowed to enter any premises or office which forms part of the Division Crime Intelligence or have any contact with its personnel as ordered by the court. You then conclude that any further inquiries be directed to Chief Investigator Perumal, and you provide the email address. So, I don't know, perhaps inadvertently you are perpetuating this injustice. Was the letter prepared for you
It
for
was
signature?
prepared for me
Yeah.
by Chief Perumal, because I wasn't thinking to the conditions, and I do see that problem of allowed any premises.
Yes.
Yes.
Yes. So,
They would have put it in as the conditions as they then saw them there and had them.
okay.
Yes.
So you would have had to work off
What they
a court
gave me.
order.
Of the court order, or at least the summary that they gave me.
So you are not seeing for the first time here in this hearing that actually there was this condition.
No. I see for the first time in this hearing this condition as it is. That was the summation that they gave me for me
It was
to
not
sign.
the actual order.
It wasn't the actual order.
So they drafted a letter for you, explained it, I take it, and you took them at face value and you trusted them implicitly and signed. That's about what
Because
happened.
it had to go to the National Commissioner, yes, what had transpired in court.
And once again, you didn't satisfy yourself that those were the correct conditions, actually.
No, I didn't ask to look at the conditions.
Okay. Commissioners and
I think it's more, especially in the light of what you said now, as you're sitting there, that this bail condition is too wide. These people are employed in head office. You may not have seen the order itself, but you sign a letter that says they may not go anywhere in the whole country. That is crime
Sorry.
intelligence.
Yeah. I didn't read it that way, in the whole country. For me, it was any
Crime intelligence
crime
office.
intelligence office, and for me, they are bound here in Pretoria. I didn't see that as in the whole country. That is why I'm saying, Chair, when I see the handwritten condition as it is, that is more explicit than what that paragraph was. It is incorrect to have asked for that condition. And I'm not sure if that's a condition that was asked for, because I'm
No,
not.
take it from us. It wasn't asked for.
Okay, because
Because your investigator says he doesn't know where it comes from. That's what he told us, because at some point he left. So he doesn't say, I was in court when it was asked for. He said, I don't know. And we've referred you to the judgment, where there is this, where the judge sets out the engagement about this condition, and in fact says that was not asked for. So I think it's at least on the evidence of Colonel Padeachi and the judgment itself, the appeal judgment, we can accept that it's established that the condition was not asked for. Thank you.
Thank you, Ms. Thank you. And if I could just perhaps add to that, you don't have to take our word for it that it was not asked for. The judge in the High Court, that's precisely the basis of his overturning it, because it wasn't asked for, and the judgment states as much.
It's just I am taken aback that there's a condition that was not asked for. It is not something that I have experienced or
Indeed.
engaged with other colleagues about. So
And then it's not something that you wouldn't expect to happen in any event.
not at all.
Absolutely. Okay, then I would like to move to the next issue. You have and I think we have dealt with the issue. You have an investigator. Let's start at the ad hoc page, transcript page 626. File 3.
Silo, you said 5?
File 3, the transcript, ad hoc transcript, page 626. Midway that page, you are having an engagement with Ms. Ms. James.
626.
Correct?
And Ms. James inquires from you, do you know Sunil Belochan? You say that is correct. Is he employed by IDAC? Say he is employed by IDAC. He has not been arrested or convicted on any matter that we are aware of. I take it that that comes perhaps from some previous conversation or engagement with some other member of the ad hoc committee. So possibly it's not the first time that Mr. Belochan is being referred to here. So you confirm that he has not been arrested or convicted in any matter you are aware of. Ms. James says there's currently a case. You said there are no rogue elements within this organization. Here you have a member that you have appointed. There was red flags from 2014, again in 2024. You said there is no rogue element. Whether he has been found guilty or not, there is a pending case against him registered in 2024. Your response is, if you say so, I have not seen it. Then she inquires about vetting systems in place. If we go to page 6 to 7, midway, 6 to 7, Ms. James says, can we agree that you have a member employed in IDAC that has 2 cases and the one has not been finalized and IDAC is compromised? Your response is that if there are cases, they will be investigated. Now, if you run ahead in the same file to CJC 376, that is an article at 678. 678.
678.
Page 678, yes. And this article, I think it's informed by comments by Pop Crew. First paragraph states that it was a startling revelation that IDAC appointed Sunil Belochan as a senior investigating officer, despite him having a warrant of arrest for alleged fraud. The second paragraph of that page then gives the detail of the docket from which the warrant of arrest comes from. We have a witness who has testified before the commission regarding the existence of this warrant.
Okay.
Ms. James at ad hoc brought your attention to the fact that there are cases pending against Mr. Belochan. And your parting shot was that the matters will be investigated. That's the one. We have a witness who appeared before the commission about 2 weeks ago, witness N. Witness N once again testified on complaints by, and I use the term liberally, the Pakistani community living, is it East London or PA, that which is said, East London, I think. It is alleged that investigator Belochan is extorting monies from and otherwise dealing with them harshly, and it's a very general summary. That's complaint number 2. The third we dealt with in this hearing, which is by Sergeant Ngosi, of Mr. Belochan leading a team of 9 people, investigators and maybe others, from IDAC of the 13th of July, 2026, to meet with him in the absence of his attorney and to solicit, again, it's my own summary, testimony from him that would implicate Generals Khumalo and Masemola. So these are 3 independent, these are 3 separate complaints. At least as regards the first, you undertook in November 2025 to the ad hoc committee that you will investigate. My question is, did you ever investigate that matter in particular? My second is, upon hearing the testimony of witness N as regards the alleged misconduct of investigator Belochan, I think and upon receipt of the exhibit file, because, I say receipt, because we ventilated the issue of Sergeant Ngosi yesterday, and by then you had retired. But you received the exhibit file, and that complaint was in the exhibit file while you were still ID. Did you investigate any of these matters to determine whether or not investigator Belochan action should be taken against him? And I won't say of what kind. And if you did, what did your investigations yield? Thanks.
Thank you. Chair, if you'll just give me a moment, there's a document I just quickly want to look for in my bag, if that's fine. Thank you, Chair. On the first matter that was raised, and we call it the Pretoria North.
Yes,
Is it Pretoria North or Pretoria West? Pretoria North,
North, I think.
I think. On the Pretoria North matter.
Sorry, you're quite right. It's Pretoria West, case number 97/05/2021. West, Pretoria West.
Correct.
Yes.
When we had returned, we had asked for everyone to give us feedback, including Mr. Belochin, because we need to follow up on what had arisen at the ad hoc.
Yes.
Mr. Belochin had gone ahead and on his own, through the local criminal record center, put through the fingerprints to see if there were any matters outstanding, because that is where we find outstanding warrants or outstanding matters on the LCRC. He gave a report back that there were no matters that were outstanding on the LCRC. And it is on that basis that prior to Advocate Batoy leaving office, we had compiled a report, Chair, which said that there was no one in IDAC, or investigators especially, that had outstanding cases, previous convictions, or pending misconduct. We fast forward to now, and we are faced with this issue again. And I was faced with it about 2 Sundays ago in preparation for the commission, because I see then in the bundle of documents that are sent to me is a J50. And in our legal language, it's alive. It dies only if it has 2 lines across, where the magistrate would have to say cancelled and sign. And it must invariably go to the magistrate who would have authorized it. I immediately called Mr. Belochin and I said to him, okay, what am I doing at the commission with a live warrant? Why is there a live warrant?
If I may, I do apologize. Commissioners, that would be in Exhibit File 1, page 136.
Yes, sorry. I got this one. And maybe before we go there, sorry, this was the document I looked for, Commissioner. When we asked him in December, January, how are we responding to the ad hoc committee? And he went ahead and on his own, got the report from the local criminal record center. It shows no illicit activity identified. It is on that basis we were able to compile the report, and I'm happy for this to become part of the record. We will share that. That is a copy. I'll give it as a pack for the Belochin matters, if that is okay with you.
But the question is, he has an active warrant of arrest.
Now, we ask, why am I looking at an active warrant?
Yes.
Mr. Belochin then indicates that this all happened prior my time, but it was in 2021. A case had been opened of assault against him. My predecessor, Advocate Hermione Cronje, had engaged with the office of the DPP this whole matter. And Advocate Mzinyati then responded to her. And I am prepared to share this as well. I tried to get what I could because I don't have a recollection. But on the 8th of June, 2021, Chair.
What are you looking at now?
No, it's a letter that I'm prepared to share that I had to find as support for what I say. Advocate Mzinyati wrote to the then head of IDAC on the 8th of June 2021, refers to the conduct of a prosecutor, Mr. Letwaba, that surrounds Pretoria CARES 97 of 5/2021, and that's the CARES number in question. I'll just read relevant portions as I intend handing this in. In respect of Pretoria West CARES, 97 of 5/2021, I have instructed the acting chief prosecutor to request that the warrant of arrest be cancelled pending the finalization of the police investigations. I have further directed that the matter may not be enrolled without my written authorization to that effect. I will decide whether or not a prosecution will be instituted in respect of this case upon finalization of the outstanding investigations and the acting chief prosecutor's report. That is the gist of that letter that was received.
If I may, I take that. That's what the prosecutor expressed in that letter.
That is what the DPP of Pretoria
Yes.
expressed in that letter.
You earlier testified what a cancelled warrant looks like.
Correct.
The warrant remains active.
The warrant remains active.
And that is really the issue, that he continues to be in office investigating, arresting other people when he himself is under an active warrant.
I got a hold of that letter. I then engaged as follows, and maybe just to make this engagement shorter. I then asked him, but this was 2021. Why is Andrea Johnson faced with it in June, July of 2026? What did you do to go and find out if the warrant is cancelled? So what he had subsequently done after my asking, because he took the word of my predecessor, he went to ask at the police station on the care system if they could determine what had happened with the warrant and or the docket. According to him, the docket is closed, marked undetected, and this docket would have been closed in October of 2024. October of 2024 or October of 2023, but it was in that time that the docket was closed. I said to him, but that still doesn't help me. The warrant is active. Now, the reason it's not found, Chair, on the local criminal record center document is it is only found there if an investigator circulates his warrant, and that is when it is seen. I have no explanation for why the warrant was not circulated, nor do I have any explanation for why, despite there being an instruction that he cancel the warrant, finalize the investigation, take it back for decision, warrant is not cancelled, docket is closed, and docket is filed. This is a police warrant, and the police will do with this warrant what they do with warrants that are not cancelled.
Okay.
It's not my decision to make. It most certainly isn't.
I think your decision was confronted with what you are confronting. One of your investigators has got an active warrant. He, in the course of his duties, is arresting other people. That is a problem for you as the head of IDAC. The warrant is for the police to deal with, to execute. But the question was, what do you do with that? Can he morally be permitted to be arresting other suspects out there when he himself is under an active warrant of arrest? I think.
No.
Yeah.
This matter, the police must act as they want to act.
And what does IDAC do in the
IDAC
interim?
This has to go to the judge, the IDAC judge, because this becomes one of those issues.
Should it be a consideration to strip him, at least temporarily, of his arrest powers while he sorts out his own warrant? I just a thought, I'm not imposing it,
I
I'm
don't
asking.
want to say anything lest the IDAC judge think I'm trying to be prescriptive in his independent duties. It would be wrong.
You can't be, you're no longer a member of IDAC. You're just like me.
Trust me, every word I say, including if I breathe too hard, can be problematic.
Okay.
So I leave that to the discretion of the judge.
Okay.
Then you asked me about witness N.
Witness N, yes.
So witness N's testimony was quite harrowing, to say the least. And after that evidence, I wrote a letter to the National Director wherein I indicated that the witness has testified, the record should be available at the Commission, and that through the Office of the National Director, it please be escalated to the IDAC judge. And I did this a week ago, or a little more than a week ago when it came out. I'm given to understand that Mr. Belochin received a notice yesterday indicating an intention for him to be suspended. And I would assume it comes only out of that matter because, Chair, that was the first matter that I have escalated to the IDAC judge. So I took the steps that I thought should be taken in that time.
Okay.
The Sergeant Nkosi complaint. We dealt with it yesterday.
Yes, we dealt with it yesterday. It's about the 13th, the events of the 13th of July. It's what, 2 weeks ago?
Yes.
But like I say, you were not hearing of it for the first time yesterday because I had shared that particular part of the
yes.
exhibit file with you while you were still ID, yes.
Yes. I didn't do anything with it yet because I was coming here to the Commission. But I had, I did say to Mr. Belochin that there is allegations against him by Sergeant Nkosi, and the allegations are serious. He has a version, but that version, again, will have to be dealt with through the channel of the IDAC judge. If I take that version, I am usurping the powers of the IDAC judge because what Nkosi is raising is not a labor issue that I can deal with. And so this matter, similarly to witness N, must go to the IDAC judge. And because it came to my attention in my time, last week or week before, as the ID, I would have to escalate it before the end of this week to the National Director for him to then take further with the IDAC judge, together with the issue of the live J50 warrant. However the police deal with it, but the judge would have to know about the warrant.
Okay. I would like to move on to another topic, and thank you for the report backs on those matters. In the course of consultation with the evidence leaders, we having, I think, thought that we understood the mandate of IDAC in terms of Section 7, Sub 1, capital A. A question was put to you whether or not IDAC is investigating, I'll call it generally, the Tembisa Hospital matter. And if so, where the matter was at. You had a response for the evidence leaders, and by extension, you have a response to that question for the commissioners. You provided a document which speaks to those matters, and you will address momentarily, but you highlighted the sensitive nature of that document and its contents, and requested that it not be made publicly available because it provides detail as to progress of investigations. That's a single page that now was circulated just after lunch amongst the commissioners. You've been provided with a copy, so we won't necessarily read from it to protect its contents, but you may address yourself to the position of the Tembisa Hospital investigation, who's responsible for it, and whatever report back you can give as regards its status.
Commissioners, I just also wanted to add that confidentiality, if I can use that, it's not just based on the state of the investigations. We report to FATF. All FATF documents have an embargo unless FATF allows us to release documents. This document is shared with me because I am part of the law enforcement team that writes up reports. I write for IDAC, the DPCI writes up their case studies. So this is a case study write-up for FATF, and that's predominantly the reason why we do not put it out in the public. It is part of our confidentiality agreement with them. However,
Maybe for the record, if you would say what is FATF, as
Sorry,
in the full name,
yes.
and then spell
So,
out the short
Thank you. The Financial Action Task Force, which grey-listed South Africa in January 2023, has had us on a watch list. And part of what we do is we identify matters that we will be presenting to them, and we meet as law enforcement every month to update ourselves jointly. SARS, where are you on this? SIU, IDAC, the different units in the NPA, DPCI, as well as detectives. And this is where we all sit and are able to glean knowledge of the work of one another. There has been a lot of questions in the media and in the public space about why IDAC is not doing anything about the Tembisa Hospital matter. More pertinently, questions in the recent past, commissioners have been raised about, so why does IDAC act on Nhlanhla but not on Maumela? And I saw it fit to raise this with the evidence leader to quash it once and for all. The Tembisa Hospital matter, in all of its forms, in however many legs of investigation it has, whomever the persons and entities of interest are, had been referred around about 2020 or thereabouts by the SIU to the DPCI. The DPCI has always been vested with this matter. The Tembisa Hospital, whether it's Skinny Jeans, whoever they are, who's behind the scenes, whether Maumela is involved or not, etc. All of it lies within the ambit of the DPCI. And it was important because we are supposed to account to South Africa, and IDAC has been quiet, but only because this matter, as big as it is and as tragic as it is not being accounted for.
Does the SIU, only because you mentioned them, does the SIU get to choose whether a matter goes to DPCI or it comes to IDAC? What guides that decision?
I think back then it was still early days. The ID had only been created by proclamation, but there is a challenge, and the challenge is with the legislation. The SIU must refer its matters to the NPA. NPA then distributes the matters to the DPCI and in turn now with IDAC. We had to come up, government really loves papers, but we had to come up with a memorandum of understanding that where a matter comes to the NPA and the NPA is able to assess it is an IDAC matter, they then refer it to IDAC. But the SIU, because there's a lacuna in the legislation, are not allowed to refer directly to the DPCI or directly to IDAC. It goes to the NPA as a conduit, and that has to be something that must be looked at because it does take up a lot of time between receipt, assessments, allocation. I hope that helped.
That answers me, thank you.
Have you made all the comments you wanted to make on the matter?
Can I say one more time, we don't have the Maumela matter. Thank you.
Thank you. I think that came across very clear. I think I'm ready to turn to my last topic. Yes, Chair.
Ms. Solo, give this back to you.
The commissioners could retain it for record purposes.
Yes.
It's just the question, I think the request is that it be embargoed, so it won't may form part of our public record, but the
Yes.
commissioners may have regard to it as a response to that specific question that was put to Advocate Johnson. And maybe as a matter that then the commission may pick up with DPCI at the relevant time. Thank you.
Thank you.
Thank you, Chair.
Did you say last issue?
The one I'm dealing with next.
Okay. Thank you very much.
But I haven't committed myself as regards its breadth or depth, but it is the last issue. Advocate Johnson, in your statement, your third statement, the statement of the 10th of July 2026, in response to a question posed to you through a regulation 10.6 notice. I'm at page 7 of that statement, paragraph 16. The question had been your relationship with General Khan and how well you know him. Your response was a fairly terse one, stating that you know that he's a general based at Crime Intelligence. Before you became the investigating director, March 2022, you engaged with him in meetings with other stakeholders and attended net joints or other subs meeting at which he was present, and to which you had been invited by relevant component heads, Deputy National Commissioner or Divisional Commissioner. So, according to your statement, you significantly played down that relationship. In the course of engagement, we have subsequently established that that relationship is actually deeper than as you describe at paragraph 16. And I think it was Commissioner Khumalo who informed you of testimony before this commission regarding the fact that you attended General Khan's 50th birthday, whenever that was. And I think that shed some light on this relationship, that besides a professional relationship, you have this personal one. As you are well aware, you may very well have heard, the Commission is in possession of General Khan's charts, downloads. And for that purpose, I would like to refer you to, I think it's File 9, Annexure CJC 388.
Sorry, Council, which page? File 9?
File 9. The version I have starts at 1. Please bear with me, I'll find the page for you.
I think it's in File 8.
File 83194. Apologies. Three, 194. 3194, Commissioner. And yes, I confirm marked CJC 388. Now, up to page 3253, these are the chats between yourself and General Khan over a period. Just as a general note, would you agree that those chats reflect a deeper relationship than just being invited to a 50th birthday celebration by a colleague? You have a personal and deeper relationship with General Khan. Would you agree with that?
Yes, ma'am, I considered him a very good friend.
A very good friend. And in fact, on reading of this, it sounds like you visited each other's families.
No, we didn't.
You have been, I don't want to flight them.
Yes.
Personally, I don't.
Yeah, but I can indicate that there might have been an occasion where he would have invited us,
Yes.
but we have not, I have not gone to his home. He has not come to my home. We
What-
have not socialized.
What happened to the, you and General Khan had agreed that you, your family, together with your parrot, will visit General Khan, and you agreed what his family would cook for you for that day.
Yes,
So what, did that not come to pass?
it didn't come to pass.
But it's the kind of relationship where you have.
Where we would talk, yes. I have met him for lunch once or twice, but not at his home, not at my home. And the first time that I attended a social gathering, Chair, was at the 50th birthday, and both my husband and I had been invited, and we attended the birthday. But I have never been to his home, and nor he to my home.
I think, I don't want to flight these. They don't take my point.
Can I suggest a way?
And read it to me.
Can you just look at 3245?
3-2?
3245. It might jog your memory. 3245, right at the bottom of the page. If you like, you can go to the next page. And as you answer the question.
Oh, that for me was, that was for me saying, I can't remember what we had been talking about, but that was for me in jest where I said, I'm bringing husband, daughter, and parrot to your home for supper tonight, start cooking. We didn't go to his home for, it's, if I could just use.
It goes
in the next
further.
page. Go to the next
Sorry,
page.
yes. Yeah, he asked us what would we have liked to eat. I indicated what we like to eat. Yes, but we never went to his home. I'm dead serious, Commissioner. We did not go to his home. And we talked often like that about what's for supper, what you cooked. I'm coming over for supper, but you don't go over for supper. Sorry, Commissioner.
Go ahead, Commissioner.
Are we still on home visits? I
Oh,
wanted to-
wait.
3249. Chat 7, and it continues all the way to 3251.
Mr. Maybe while Advocate Johnson
Yes.
considers this, you should think about providing an explanation why you're not flighting this. We have flighted people's WhatsApp exchanges, and I think there has to be an explanation why.
There are a number of messages where they are communicating about minor children. And we've tried to do some deductions. In some places, we end up with quite a lot of blacked out parts. And the purpose of my referring to the charts is to establish a very, very close relationship with, between General Khan
And myself.
Advocate Johnson. And if Advocate Johnson were to confirm to you that theirs is a very close relationship to a point that they greet each other by stating, saying words like, "Hi, gorgeous," then it makes my point without necessarily having to use the chats. So the chats are not going to give me any relevant evidence for anything except to establish this very close relationship, contrary to what she had stated originally in her statement. Thank you.
So Advocate Johnson, if you just look at chat 5, 6, 7 on 3249, and then it continues to 32. That is a sign of people who have a close personal relationship. And you can see there that it's not an IDAC investigation. It's really two people who are friends, and this relates to a favor to him. It has nothing to do with IDAC's work. If you just look at 3249, I will just read, for example, where he wants to know who's plotting against him, and you are to assist him. And he suspects that it is the Hawks that are plotting against him, and the two of you decide to meet, and you arrange for him not to sign in the normal course, but to come in via the VIP entrance and come directly to your office without going via reception. I mean, that's a summary of it. I don't want to go into.
Yes.
That's what it shows, at least to me. And if I'm wrong, you can say
No,
you're reading it incorrectly.
So usually, just on a point of correction, usually when we do, and he's not an exception to the rule, when we do invite high-ranking police officers to the office, we usually let them use the side entrance, and you will see, even if you go now, if there's high-ranking police officials there at the head office, we grant them that entrance.
But you see here, the purpose of the visit was to come and see you
Yes.
a personal matter.
And he did.
Yeah.
And it was a personal matter, and the
Advocate
matter-
Johnson,
Sorry.
if I may, with your leave, if I may, I have argued against projecting these messages because they have a lot of personal material involving, children. And I now have a difficulty with your response to Commissioner Khumalo's question. What Commissioner Khumalo refers to is not how VIPs visit your office. He wasn't coming in his capacity as a VIP. He was coming in his personal capacity, requesting a favor from you regarding suspicions that he's being investigated by the Hawks and the like. And from that conversation, one picks up that the two of you are planning at some clandestine meeting. You end up, because of diary issues, you end up inviting him to your office. and then to avoid a record of the visit, you suggest he use that entrance. I beg of you, please don't make me do it.
No, I'm not disputing that he used the entrance. I'm telling you, ordinarily it was done. Here, he did come to visit me. And unfortunately, when he did come to visit, it turned out it wasn't anything to do with the Hawks, but he had an issue about somebody plotting against him. It did turn out that it wasn't the Hawks. I want to make that clear. But it was...
The point is, this is not a VIP visiting IDAC office.
No, this was my friend.
This is a personal visit by a friend, and when you say to him, come via VIP entrance and don't sign in, you're not doing that for a VIP coming in his official capacity. You're doing it for your friend who's coming there to discuss personal issues.
I accept that, Chair.
And that is the whole point, to demonstrate that you have a very close relationship and the lengths you'll go to accommodate one another. I referenced how you address each other at times, either calling each other gorgeous, you tell each other how much you miss each other, and that's yes, dearest. Okay, now have we established the relationship? It's a very deep and personal one.
Yes.
And a very close one.
Correct.
So then,
Can I just add that what also seems to appear from this personal relationship is you also discuss, as friends, close friends, you discuss things that have to do with your work. For example, you've mentioned the Hawks issue. I'm looking at page 3243, where he wants you to tell him who said something, and you say, I will tell you when I see you. For now, be smart, and it's this second part that I'm reading that can be a source of concern. You say, for now, be smart about who you trust at work. Please don't say anything to anyone about you had someone is out to get you, because you could be talking to the culprit. So you and him are discussing matters that have something to do with what's happening in his workplace, and you're advising each other, and you're reporting to each other. That's what that message is. Okay, thank you.
and if I then may conclude on that note, it goes further, and one picks up from the charts that both of you have a very close relationship with General Sintumule.
Yes. Well, I don't know how close his relationship was with her, but I had a very close relationship with her.
No, you must be aware, because when General Sintumule, according to this chart, was down with COVID, you and General Khan were planning what you should cook for General Sintumule, some dal soup and other fancy soups. And there were complaints that she's not picking up. You advised, no, she's not picking up because due to her level of incapacity, she was advised to switch off the phone. Then it comes back to you at some point, I eventually managed to talk to her. So you do know that he too has got a close relationship with General Sintumule, and the issue is that both of you have this relationship, and you were both concerned when she contracted COVID.
Correct.
Okay. Now, all this is relevant to the testimony of witness, I've run out of alphabet.
Witness Roloff, sir? McLean?
Witness O.
Oh,
Witness O, thank you. Before we get to witness O, you will recall that on the 7th of July, 26, the commission issued you with a subpoena requesting that you submit certain documents. And that subpoena is dated the 7th of July, 2026. I think you've been provided with a copy. The request there concerned certain dockets. Firstly, it was 1.1 recopying an affidavit received, a copy of that affidavit received by IDAC regarding Brigadier Mkhwanazi's appointment. The second was all emails and or other written communication between yourself and witness O, stationed within the Division Crime Intelligence on or about the 4th of July 2018 regarding the complaint lodged and criminal case opened by Brigadier Petle against General Feroz Khan for an alleged assault. The third request was in respect of dockets into the investigation of Mr. Inabath Kistia. I apologize if I mispronounced.
Ibanat Kistia.
Mr. Ma'am?
Ibanat Kistia.
Ibanat Kistia, thank you. And the last was dockets in respect of investigations into General Masemola's and General Mkhwanazi's alleged receipt of the Louis Vuitton bags from a sub-supplier. So those were the documents requested of you. You were able to provide all the documents requested except for the emails and the written communication between yourself and witness O regarding an incident of around July 2018 involving General Khan, in which he is alleged to have assaulted Brigadier Petle.
That is correct.
Your response, your explanation for failure to provide that information was that this goes back to 2018 or 8 years ago, 7, 8 years ago, and that your emails do not go that far.
My Gmail.
Your Gmail doesn't go that far, and therefore you are unable to retrieve any record of communication between yourself and witness O. I then informed you that witness O has made available certain documents and emails, and I gave you her complete bundle regarding this matter, which is what she testified to, and I asked you to consider whether, upon consideration of these documents, is there anything you dispute, that you take issue with, that although you don't have your own, you do not recall being correct and accurate. And you led me to understand that you have no basis to challenge the accuracy of the documents provided by witness O. Am I reflecting your position correctly?
Correct, because I didn't have my own emails, and I didn't have a recollection. I can't dispute what she had.
What you recalled was the act itself that witness O testified to, and that was the act of your sharing the docket in respect of Brigadier Petle's complaint with General Khan. You recall? You admitted at least having that recollection.
I had a recollection, as I explained in our consultation, that I had shared documents with her. It is when you showed it to me that I realized what it was that was shared. I just wanted to correct. I didn't dispute what was shared.
Yes.
I could not recollect what was shared, and because of her record, I was able to look at it and confirm.
And we engaged about the contents of the exhibits of witness O's annexures, including the statement by Mr. Barry Bateman explaining the circumstances under which the docket was shared with Mr. Khan. At the time, you had an explanation for what transpired there. So, and I point that out to state that the fact that you have an explanation as to what transpired based on documents you did not give means that they triggered your memory. Upon considering and reading the papers, your memory was triggered and you remembered what transpired. Am I correct thus far?
Correct.
And lastly, you indicated that you cannot shed any further light because of a non-personal relationship you have with General Khan. And, you expressed your relationship, at least to me, during consultation, in the same terms that you have in your statement. But we know that's not correct. We've established that this is a very, very close and personal relationship. So I say, you must know why and under what circumstances you shared that docket with General Khan. It cannot be, I don't remember because I don't have such a close relationship with him. We've established that cannot be a basis. You've had these documents for 2 weeks now. I'm sure you have read and reread them and are able to assess.
Chair, it is, sorry, if you'll just let me.
Oh, if you are looking for the documents, it's Exhibit 1, CJC 368, starting from page 1.
Yeah. Now, I was just looking for my supplementary statement
Your supplementary state to the commission.
to the commission.
Have you located it?
We have located
Okay.
it. And commissioners, it is in file 1, and I do not wish to belabor a point. I have read this into the record, and at the stage where we are, and I'm expected to perhaps respond and answer a question, I just wanted to indicate, Chair, that and it would be on, there's a red number 2 on the page, and it would be the supplementary dated the 20th day of July, Chair and Commissioners. Chair?
Yes, please do.
Sorry, I proceed at paragraph 5, where I read on day 1, and if Chair would allow me to just reiterate. I said the notice requires me to deal with allegations against me testified to by Colonel Kobus Rolofse, Captain McLean, and Witness O. The allegations, as summarized, implicate me in alleged criminal conduct. The allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so, Chair, was confirmed by the NPA on the 10th of July 2026, as well as by the witness McLean when he testified on that day. Now that the matter is before the NPA on the basis set out above, Chair, for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need for me to have my rights protected. Thus, when I testify on those matters, should I be called upon to do so, Chair, I will humbly exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. If I could just read the last paragraph then, Chair. I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. And it is for those reasons, Chair, that this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above formally before the Commission.
Two things. You say you were informed that the matter is before the DPP to decide whether or not to prosecute. Is that correct?
That is correct.
Or to proffer charges against you. So that decision is not in yet. It's not there. Correct? There is no decision to prosecute right now.
There is a docket that has been sent for prosecution with its evidence, meaning that a decision must now be made, Chair, on whether or not I should be prosecuted.
And I maintain there is no decision to prosecute. There isn't. It's awaited. That's the first. And if the decision has not been made and you are not under prosecution, I'm sure you appreciate you cannot invoke the rights set out in Section 35 of the Constitution, because those are the rights of an accused person.
Correct.
Okay.
That I do invoke the rights of the Commission.
Indeed.
And as I appear before the Commission,
Indeed.
Mbuyiseli, I therefore invoke those rights, as those rights are also set out to protect me in terms of my right not to incriminate myself.
I have lost my note here, and you rightly refer to Section 3(4) of the Commissions Act. But you know it must be read with the regulation. You are aware that anything anyone states and testifies to in the Commission that has the potential to self-incriminate cannot be used against them in any subsequent criminal proceedings.
It can, however, be used by investigators, as has been the case, to roadmap further investigations against you, to enhance and bolster their case.
My question remains unanswered. There is that guarantee that anything you say in this commission cannot be used against you in subsequent criminal proceedings. How that information can be used is the second part, and we'll deal with it. But what it cannot do, that information can be used against you. Things that you uttered, they can be used against you. It's a legal position. You have to accept that. It is what it is. I quite appreciate the risks that you highlight. We'll get to them. But you have to accept that that's what the law provides. Advocate? No, the commissioners can multitask. They dig through papers while listening.
Sorry, Ms. Silo, yes, Section 35, 3J refers to an accused person. But does the issue of accused person apply to Section 3, subsection 4 of the Commissions Act with regard to the privilege against self-incrimination?
No, I distinguish between the two.
Yes, yes.
Here in her affidavit, she's raised both.
Yes,
Section 35 of the Constitution, and I say that doesn't apply in this case because she's not an accused.
Okay.
So she can only resort to 3(4) of the Commissions Act.
And then you raise the issue that such evidence
Exactly.
cannot be. But what about the point of derivative evidence?
And I think this is...
Which would be maybe quite prejudicial under certain circumstances, depending on what has been derived, even if they don't use what a witness may themselves have said. But
Which is the second point she raised, and I said I distinguish between her acknowledging that there are those provisions in the law. She mentions precisely the issue that it may provide a roadmap for future investigations, precisely to ensure a successful criminal prosecution. So I say that is the second leg. So the chair is slightly ahead of us. We were still recognizing that what she says by law ought not to be used against her. It's not lost on me the value of whoever wants to initiate criminal prosecutions to follow the evidence of the commission and perhaps have a thinking and an investigation angle that they would otherwise not have had to arrive at the very conclusion that the Act seeks to protect the witness against.
Also, perhaps you will again say I'm already ahead. I'm thinking, under what circumstances then would this privilege work in practical circumstances if a witness can always be told, but what you have said cannot be used against you? Wouldn't that bring to naught the very entitlement under Section 3, subsection 4?
Yes, but the witness in her statement suggests that any issues pertaining to, I'll say, witness owes evidence, she cannot respond to. So her invocation of that section is way too wide.
Yes.
I think she's entitled to say, I cannot answer maybe for fear of self-incrimination, but she may do so only in response to a specific question. Her affidavit suggests, don't ask me anything.
Yeah.
So that is the practicality of it, as I see it, Chair.
That I get, which is why we engaged in the rather schizophrenic approach, which I think was forced on us by circumstances with Mr. Mkhwanazi. It was question by question, and he raised his entitlement not to incriminate himself.
And
But
that's exactly what I seek.
We still went through the process, and I felt like dying. But
I shall not be the cause of your death, Chair, I promise.
No.
I'm trying to.
No.
I understand.
I've just made the point that I understood why we had to do it.
Yes.
So which automatically means that even in this instance, I understand why it should be done. Yeah.
In fact, I think we are about all running on empty now. It's an approach I would prefer not to have to engage in. It is laborious. And at the end of the day, it achieves, I think, for purposes of the Commission, very little, if anything.
In this case, actually, I agree with the point you've just made.
Yes.
In this case, Advocate Johnson, witnesses have given what, on the face of it, appears to be very strong evidence that you did share the docket with General Khan. Very strong evidence. What could have countered that would have been testimony from you, which, as we now see, you are not willing to do. Without contradiction, that very strong evidence may lead to a conclusion by us that those witnesses were telling the truth.
I understand.
I hope you understand that this has nothing to do with the unacceptable drawing of inferences from your failure to testify. That's not what I'm talking about. What I'm saying is the evidence on its own is so strong that if not countered, it may easily lead us to the conclusion that you did share the docket with General Khan.
I understand.
Yeah. So, which perhaps may obviate
Absolutely.
the need for us to go through this laborious and painful exercise.
Indeed, Chair. It's too horrific to contemplate. I too wouldn't want to go through it. But then it goes further as regards inferences that we suggest be drawn by the Commission as all the evidence tendered by witness O must therefore be accepted, particularly in circumstances where you were provided with an opportunity in this Commission to contradict any aspect of her testimony. If you don't, then the commission will have no basis to reject any suggestions and any conclusions she could potentially have drawn from the evidence that she has tendered. Are you happy with that?
I understand. May I ask the chair just for a 5-minute indulgence, just to speak to the legal team?
Thank you. Well,
And then we also would like to make this as painless as possible. But
thank-
I hope that there's an appreciation
Yes.
that there are rights that I would like protected.
Thank you. We'll adjourn, we'll come back when we are told to. Let's adjourn.
Thank you, Chair.
One, it seems we are ready to resume. Please make sure your devices are off. Thank you.
Yes, Ms.
Thank you, Chair, and thank you for granting Advocate Johnson an opportunity to confer with her legal counsel. Advocate Johnson, then to recap, as you correctly pointed out, Mr. McLean testified, so did Mr. Rulofse and Witness O, and all of them testified on matters relating to your sharing of the docket and implicating General Khan in an assault with General Khan, pursuant to which General Khan then prepared his own statement to the police. That's in summary what their evidence was about. We are at a point where I must give you an opportunity to challenge any of the evidence that they tendered to the commission. And if you elect not to, I think it's incumbent upon me to draw to your attention that that evidence as tendered by them stands uncontroverted, and the commission would have no basis to reject any aspects thereof. Do you appreciate what I'm saying, and what is your response to the opportunity to challenge any of the evidence of the three witnesses I've named?
Thank you, Chair. And I must at the outset indicate that this is not a decision I make lightly, nor do I make this decision to frustrate the Commission. I have come to the Commission, as I have over several days, and have answered as best I could on all matters. This matter, however, affects me directly. I am aware then that should I choose not to answer any of the questions, they remain unchallenged. I elect not to answer questions so as not to incriminate myself.
Sorry, and that will be in relation to all aspects of each individual witness's testimony.
That is correct, Chair.
Yes.
Can I just check, does that include the testimony about your interaction with Mr. Bateman, Barry Bateman, and there's two parts to it. There's the first, which results in the docket coming to you, and then there's the second part where he says you've called him. He's filed an affidavit. He spoke to you. I mean, rather, you spoke to him after all of this had come out, when you became aware of the investigation. Is that part of what you say? You accept that, firstly, you take a view, you're not going to speak to it, but you accept that it will stand as testified to by the other witnesses. That
is correct, Chair.
You accept that, okay. And one last question about that for me. At the time, and this doesn't raise a self-incrimination kind of answer. At the time that you are communicating with Mr. Bateman, was he a journalist? I think he's moved on now he will forgive me if he's not at AfriForum, not that there's anything wrong with that, but I think that's where he is now, yes. But at the time of your communication with him, he was a journalist at the time.
That is correct, Chair.
All right, thank you.
There's the part where you spoke whilst Commissioner Baloyi was speaking. I just want to place it on record. You said Mr. Bateman is with AfriForum.
Currently,
right?
yes.
Right now. Thank you.
Thank you, Chair. Chair and Commissioners, I guess that takes care of that issue and matters arising from the testimonies of Mr. Matlin, Mr. Rule Officer, and Witness O. And based on the position that Advocate Johnson has assumed, notwithstanding a formal invitation to her before the Commission to persuade the commissioners otherwise as to the correctness of that evidence, then there is no point in going through the evidence, because I think she's given a total answer to those. And I guess the cards shall lie where they fall. I don't need to take that topic further.
That means should we take it, you will then make submissions to us that the evidence of those witnesses should be accepted as true.
I make the submission now and point out to the commissioners that that evidence stands wholly uncontroverted. The singular witness who could have challenged that evidence has elected not to. The reasons thereof become irrelevant. What is relevant is the weight of that evidence before the commissioners. And I argue that it has to be accepted because there is no other basis, in fact or in law, to question the accuracy and correctness of that evidence.
Thank you, Mr.
Thank you, Commissioner.
We'll see what to do with it when we prepare our next report. That's your last issue.
That's my last word on that topic. I just have one small question. And this one
is small.
minute. This one, I have to go into the chats and flight it, because unlike the position I previously assumed, it really doesn't, it's not necessary to, well, it does speak to the relationship, close relationship you have, but my interest in it is slightly different, and it's off your testimony. But I think it needs to go on record. It's a matter that will become relevant to the Commission going forward. And for that purpose, I would like to refer you to page 3222 of file 8. This is a message sent to you by General Khan on 7/9/2021. And that's on the 9th of July. We know the date is the American version. Now, my interest in this particular message is General Khan is sharing with you details about a bust he was involved in at a business premises in Eraton. Gives the date of the 9th of July. Second paragraph, we've had testimony regarding that bust. It involved on record the seizure of 541 kilograms of cocaine. You might have heard about it, or perhaps not, but what I state to you is factually correct. I'm interested in what General Khan says to you at midway the second paragraph. And he states that 552 blocks of pure cocaine were seized with a street value of approximately 200 million. Why it strikes me is we've always known the Eraton bust to involve 541 kilograms, and that General Khan was a part of that eventual seizure. I find it interesting that in a message to you, he's got a slightly different weight of 552 blocks. So just to confirm that you got this message, not suggesting that you know anything about that.
And just to confirm that the reason this message would have come is at the time in 2021, we were dealing with organized crime matters. And very often, even General Kadwa, for example, would activate us to say, at the DPP office, there is such a matter, so that we looked out for the matter and we were able to allocate resources to them. But this is the message I received.
Yes.
And so your conundrum is real about why in this message, you have 552, which must be the correct number.
Which must be the correct number, because one would think this message was created contemporaneously with the seizure.
And probably on the scene at the time.
Exactly, and 5 years later, we sit here and we are talking about a different tonnage. But like I said, this is not a matter that you can shed light on. I guess the commission will have to pick it up with General Khan at the right time. Thank you. Chair, with a response to that question, that brings a close my leading of the testimony of Advocate Johnson, unless the commissioners have further questions. Thank you.
Thank you, Ms. Sillo, so much for promising us that we would be done by tea.
If I may, Chair, with your leave, that promise more or less stood. It might have pushed to lunch, except I actually commenced with my engagement with the witness after tea. The first part of the day having been taken over by the commissioners.
Thank you, Ms. Sillo. Advocate Johnson, thank you very, very much for staying with us for as long as you did. Most appreciated.
Thank you, sir. It was my duty.
Yes.
I'm no longer the head of IDAC.
Yes.
But what I would like to ask is, given that we are 2 years old, I think sometimes people lose sight of certain things. I do appreciate, as a result of the engagements, what has become apparent is that there needs to be a few more checks and balances than there currently are. And I am hoping, Chair and Commissioners, that would be at least a part of those recommendations, so that we are able to take them on board, or IDAC and the NPA can take them on board. We have a duty to the country. And so and because we have a duty to the country, we have to rely on sound minds as yourself to where we have erred. At least point out our errors and hope that we find our space. It was created for a specific reason, and I'd like to think that that reason fulfills itself even in my absence. And thank you, Commissioners, for the opportunity. And I would like to thank Advocate Sello for being as kind and patient as she has been. We've had long days. So thank you, and to my councils as well. Thank you.
Thank you, and perhaps something I should say is that despite what may have been a grueling engagement, you still found time to put in a few words of humor. Thank you very much.
Thank you.
You are excused, Advocate Johnson.
Thank you, Commissioner.
Thank you very much. Let us adjourn and resume at 9:30 tomorrow.
Thank you, Chair.